But did you know that Africa is the place where the body of the first man was found? My daddy says that makes it the place where all people originated from. I'm from Africa, you from Africa, you African booty scratcher.
We make niggas disappear like that triangle out Bermuda. They can't find his body, but they know that I'm the shooter. I say cut my sentence in half, and I spread a little rumor. Deal? Well, you can look in Oklahoma if you want to find them sooner.
Yeah.
And obviously,
Yeah, welcome back to the book of the SGI. The book of the SGI talks. And we first to get to this bill, something to pull up and roll up to. You know, I'm so glad that you showed up to comment, like, subscribe, tell a friend, and do it again. Do President Trump have more power than the U.S. district judges? Now we're gonna sit back and listen to the arguments that they had in the courts, but we're gonna get the perspective of an attorney named Andrew Brinker, which is gonna be the narrator for us. He also is an attorney. So sit back, relax. Once again, make sure that you're pulled up and rolled up. You know, I'm so glad that you showed up. To comment, like, subscribe, tell a friend, and do it again.
obviously, these are the three judges up here. This is the White House Department of Justice lawyer on the left, the bottom left, and the California Deputy Attorney General arguing the case for Gavin Newsom. Why Gavin Newsom should be Commander-in-Chief will be on the bottom right here. Everybody ready? It's an hour-long video, and I'll be interrupting. So,
as the authority of the United States that rendered him unable to execute federal laws. Yet the district court.
Woohoo! first $10 super chat. We're 5% of the way to live shit posting on X tonight.
As the authority of the United States that rendered him unable to execute federal laws. Yet the district court improperly second-guessed the president's judgment about the need to call up the guard in order to protect federal property and personnel from mob violence in Los Angeles.
Mr. Schuman. So I want to start by drilling down on one aspect of our standard of review. And I'm going to be discussing subsection 3 only of section 12406. And you just said the president acted well within his discretion. Again, just as to section 3, is it the United States' position that the court has no role at all in reviewing what the president has done in calling forth the militia under subsection 3? Or is it the United States' view that the court has a limited role and needs to afford the president very substantial deference? Or is it something else in deciding whether the requirements of subsection 3, inability with the regular forces to execute the laws?
Amazon wants to ban this air purifier, but there's nothing they can do about it. No one believed me at first, but now they all want one. My friends made
is met.
So this is a bit of a complicated issue because my position, the White House position, the U.S. Supreme Court position is that the courts have no role here. That this is solely within the discretion of the presidency. It's non-justiciable. But if you believe it is justiciable, but the courts are supposed to give the president discretion, the issue we have here on appeal is that normally the appellate courts Just like we're saying the trial court was supposed to give discretion to the president, this appellate court is supposed to give discretion to the trial court, to the court of Judge Breyer, when he makes a factual finding. Now, I think his factual findings were insane, but nevertheless, he made factual findings. And normally, the appellate court will not reverse a lower court's factual findings, absent what the appellate court considers to be abuse of discretion. So we get into this kind of escalating series of hurdles that Trump has to go through. If you believe the courts have any role, well, the lower judge, Breyer, played a role. He made factual findings. And if you believe he has even that role, this appellate court has a high burden, in theory, before they could reverse Judge Breyer.
Thank you, Your Honor. Our view is that this statute commits the decision whether to call up the forces to the president's unreviewable discretion. So no, there's no role for the court to play in reviewing that decision.
And of course, the courts hate this argument because it's telling the court that there is a limit to their authority. And the courts cannot bear the thought that there is some question they don't have authority over, that there is some jurisdiction they don't possess. The courts want to believe no matter who you are, where you are, what the subject matter is, what nation you're in, what nation you're a citizenship of, where you are on Earth or anywhere in the universe, you cannot be beyond the reach of the unelected black robe tyrannical inferior federal district court judges. They can get you anywhere. There is no question, no point of authority they have no control over.
And I think it's important to note that the statute here is very similar to the statute at issue in the Martin case that we've cited, the Act of 1795, which had a similar structure. It had the whenever clause followed by a delegation to the president to call up the militia. And in that case, the Supreme Court in 1830 said, that's a decision that's committed to the president's discretion. It's not for a court to review that decision. The plaintiffs try to make out that decision as an outlier, but of course, there have been many cases since then involving unreviewable decisions committed to the executive. The last we cited is the Dalton case.
So is it your view that if the president or a future president simply invokes the statute, gives no reasons for doing it, provides no support for doing it, and there is nothing which would appear to a court to justify it, that the court still has no role at all in determining whether the president, this hypothetical future president, correctly invoked subsection 3? No role at all, even if the president gives no reasons and there are no facts offered by that president to support that president's decision.
That's correct, because if the statute is unreviewable.
So the position of the White House here better be, that's correct, there is no judicial role. The check on the president's exercise of this authority is not a judicial check. It's a political check. It's a check by the Article I legislative branch, and it's a check by the American body politic who is free to elect someone else president next time.
It's unreviewable. And I would point the court to the last section of the decision in Dalton, where the Supreme Court recognized, yes, Marbury versus Madison says the court decides what the law is, but it also respects that principle when a court recognizes that when a statute is delegating broad discretion to the president, that respecting that also is a judgment that a court should respect. It respects the separation of powers when Congress delegates that decision to the president. But I think, Your Honor, you're speculating about harder cases down the road. This is an easier case because there are facts in the record here that strongly support the president's decision that there was a rebellion and that the president was unable to execute.
That's another excellent point by the White House. Whatever your hypothetical nightmare scenario is that a president with no evidence might do this in the future, that's not what happened here. The dispute before you has evidence.
Federal laws under the third prong that we're focused on here today.
And what if, would your answer to Judge Bennett's question be the same if in the hypothetical, the president articulated a justification for his action that was not one of the enumerated purposes in 12406?
Again, I think I would give you the same answer, Your Honor, that if it's unreviewable, it's unreviewable. The Martin case also acknowledged, yes, there can be cases where discretion can be abused, but in that situation, there are other checks on the president through the political process. It's not
There
for
you
a
go.
court to exceed its authority just because there may be hypothetical cases in the future where a president may abuse his authority. The president hasn't done that here, as we.
No, go ahead, sorry.
So suppose that we don't agree that the question is completely unreviewable. What does it mean for the president to be unable with regular forces to execute the laws?
It means in his judgment.
In his judgment, that's the right answer. It's in his judgment.
40 years.
That's how long we've been off-grid homesteaders.
Sure sounds like a long time, but it's gone by in the blink of an eye.
The regular forces on the ground in Los Angeles aren't adequate and sufficient for him in his judgment under the Take Care Clause of the Constitution to carry out the laws and enforce the laws. And then here, I think the Santa Cruz declarations make that pretty clear. Paragraph 7, for example, talks about specific immigration enforcement actions that were unable to be accomplished because of the mob violence preventing ICE officers in Los Angeles from carrying out those actions.
But I mean, in the normal course, the level of resistance encountered by federal law enforcement officers is not zero, right? You go to arrest people, and sometimes they don't want to be arrested, and they run away or even resort to violence, and sometimes they get away. So does that mean that the president, every day is unable to execute the laws, and he could invoke this, whenever?
He decides, and then he's subject to political checks and balances.
Well, I think, let's remember, the president also takes an oath to support and defend the Constitution. He has an obligation to take care that the laws are faithfully executed. And I would point the court to the language about the regular forces, right? That, I think, provides some guidance to the president about, look, if regular forces are capable of addressing, the one-off situation where there's resistance to federal authority, there's no need to invoke this statute. But what we have here is a documented record of sustained ongoing mob violence continuing through this past weekend in the supplemental declaration that we filed that explained there were 1,000 violent protesters this past weekend outside the federal buildings, and it required the National Guard. They were essential to protect that building from the breaches that had occurred the prior weekend. So
is the United States still arguing that this case is governed by the political question doctrine?
I think that's an alternative argument. The argument we're pressing today and in our motions papers are, the Dalton and Martin line of cases that this statute confers unreviewable discretion on the president.
Well, with regard to your alternative argument about the political question doctrine, are you aware of any Supreme Court or Court of Appeals case in which the political question doctrine has been applied to a claim alleging that the executive branch violated a statute?
I don't know off the top of my head, Your Honor. Again, the argument that we're pressing today is based on Dalton and Martin, that the statute here confers unreviewable discretion on the president. We're not, at least for purposes of this motion, we're not pressing the political question doctrine.
Are you familiar with the 1932 Supreme Court case of Sterling versus Constantine?
I'm not familiar with that case, Your Honor.
All right. I would just note that in that case, in discussing this power of the president and prior cases, the court said the nature of the power also necessarily implies that there is a permitted range of honest judgment as to the measures to be taken in meeting force with force and restoring order. And I'm not going to ask you further about the case since you're not familiar with.
First of all, that sounds like dicta to me because it doesn't sound like it was a controlling presidential issue that he was addressing here. It sounds like something that was said in passing. And in any case, of course, there is a range of honest opinion. That's not the question. Everybody knows it's theoretically possible a president could just fabricate a need to call out the National Guard. But the check there is a political check. He's subject to impeachment. He's subject to not being reelected. Just because there's a range of honest takes on whether the National Guard should be activated, and therefore there's a range of dishonest takes, doesn't mean the courts get to make the call.
With it. But I take it the United States' position, again, in answer to Judge Miller's question, is even if we reject your view that it's absolutely unreviewable within the language I just read, it's the United States' view that it fits, the facts here fit comfortably within that language.
I think that's right, Your Honor. Again, so even assuming this is not a political question and that this is something that wouldn't fall within that line of cases, there is this line of cases, Dalton, Martin, involving statutes that delegate broad discretion to the president. There's a long history of courts not reviewing the president's discretionary decisions. And I would point you to the language of this particular statute. It says the president may call into federal service members and units that he deems necessary, right? So that is an express delegation of Congress's power to call up the militia to the president.
The word is dicta, D-I-C-T-A. You spelled it correctly. Sometimes referred to as obiter, O-B-I-T-E-R, dictum, D-I-C-T-U-M. Dicta is the plural. Obiter dictum just means a passing, that's literally, obiter dictum is Latin for passing remark. It's a remark that a court makes that's not essential to its ruling in the case. And therefore it does not have precedential authority.
Well, it's in such numbers as he considers necessary, right?
Correct. So the president has the discretion to decide what level of forces are necessary to counter the threat. And the threat is in the last phrase of that first sentence, necessary to repel the invasion, suppress the rebellion, or execute those laws. And in the president's judgment, 2,000 National Guardsmen from California are necessary to execute the laws in California. And the record bears that out, based on the fact that we have declarants from ICE explaining that the National Guardsmen are essential right now to protect the federal buildings from additional breaches and violent rioting involving fireworks, Molotov cocktails, concrete chunks being thrown at ICE officers who are simply trying to prevent individuals from interfering with enforcement operations and trying to breach the buildings.
So suppose that we had a hypothetical where, suppose there was no violence, no organized opposition at all. Everything is calm in Los Angeles. And the president says, I've decided that there is a numerical target for the number of removals I would like to have. And with the number of ICE officers that I'm able to hire using the funds that Congress has appropriated, I can't hit that target. Therefore, I find that I'm unable to execute the laws, and so I need to call up
Governments of subsection.
There's no need to invoke this.
Sorry.
Therefore, I find that I'm unable to execute the laws, and so I need to call up the National Guard under Section 6. Setting aside, I understand your first line argument that the judgment is completely unreviewable.
So this guy is acting as if he were on the U.S. Supreme Court. He's supposed to be addressing the dispute before him, the facts before him, not exploring public policy hypotheticals.
Do you think that would meet the definition of unable to execute the laws?
It certainly could be. Again, it would fall within the president's discretion based on the facts available to him. If we're in a world where this is not reviewable, then that would be a decision that the president could make. And if it's an abuse of that authority, there are measures to or means by.
That is not this case. They're making up these Chicken Little, the sky is falling, speculative, imaginary scenarios, none of which are what's happening here.
Which the other branches, Congress, can check that decision. But I think the conditions also suggest some type of intervening event rather than an election, right? Like an invasion in the first prong suggests there's some type of activity that interferes with the security of the United States. The second prong, rebellion that rises up. The third prong, some external force or activity, right? That requires the president to act, not an election. But again, I think that would be within the
mere dissatisfaction with the.
So this website that I'm on right now lets you invest into real estate for as little as a few $100s. It doesn't require me to deal with tenants or rehabs, and it is completely backed.
The level of the regular forces that Congress had provided would not be enough under that definition.
Well, I wouldn't want to concede that, Your Honor. I think that would be the president's decision based on all the facts available to him, and the record may support it in a particular case. But obviously, that's not what happened in this case. The president acted.
So counsel, let me ask a question based on Judge Miller's hypothetical. So let's take a look at the facts that Judge Miller posited, and let's say that the problem was limited to California.
What if we had a situation where the federal judiciary started acting like a bunch of unelected, black-robed, tyrannical, inferior district trial court judges that believed they had unlimited authority to veto anything the president had? What should we do then, judges?
That there was nothing to suggest that the problem was beyond California. In your view, if a hypothetical future president made the decision to call up in response the militia of every state and the District of Columbia, so 51 militia, would
the remedy would be political. The Congress could go for impeachment, arguing that the president has exceeded his authority.
it also be your view that that decision by this hypothetical future president would be entirely unreviewable?
Yes, because the statute says the president may call into federal service members and units of the Guard of any state in such numbers that he considers necessary. That is an express delegation that couldn't be any more clear, that the president gets to decide how many forces are necessary to quell the rebellion, to execute federal laws. But again, bringing it back to this case, that of course, that's not what he did in this case. He only called up 2,000 National Guardsmen. The Secretary of Defense.
Yeah, this video is from yesterday, folks. It's a playback of yesterday's oral argument in the Ninth Circuit. By the way, when I talked about doing this live S posting, I just want to make clear to everyone, you don't need to be on X. This will be streamed on YouTube. You just have to be on YouTube. I'm going to share, I'm sharing this for one evening of this evening.
On the ground today.
Evening, and I'll see you all again in the morning, of course, then.
Found it was necessary to call up an additional 2,000. And the facts on the ground have justified that decision. Those guardsmen are necessary on the ground today to prevent breaches of the federal buildings, to protect ICE officers when they are conducting their law enforcement operations. The guardsmen are not conducting law enforcement. They are charged with a protective mission, not a law enforcement mission. I'm happy to talk further about the conditions, but I also like to talk about the second issue that the district court focused on, which was whether the Secretary of Defense committed a technical violation of the statute by not issuing the orders through the California governor. As you know, the district court found that the Secretary of Defense committed a procedural footfall by not issuing the orders through the California governor. But under the statute, the governor is merely a conduit, not a roadblock or a co-executive when the president decides that it's necessary to call up the Guard. And in this case, the Secretary of Defense complied with Title 10 by issuing the orders through the governor via the Adjutant General in California, who is the governor's chief of staff for these purposes and is delegated authority under California law to issue orders in the name of the governor. And I think the facts bear out that that was the right decision and the right procedure to follow, because the California Adjutant General followed the order, forwarded the order to Governor Newsom, and the order was complied with. The whole point of this element of the statute is to ensure that there's a smooth handoff in the forces from the state.
Counsel, I'm going to ask a variant of this question to your friend when it's his turn. But do you read in the district court's order on this point a definitive statement of what it was that the secretary should have done to comply with this supposed requirement that obviously the district court found that sending it to the adjutant wasn't sufficient? But do you see, how does the United States interpret the order in terms of the specificity of this wasn't enough?
Well, the order doesn't tell the White House what to do, because the order says the White House, regardless, doesn't have the authority, that Trump doesn't have the authority, because the lower court says there is no rebellion, meaning there's no threat to the entirety of the U.S. government, and there is no inability to execute the laws because some small fraction of the laws are still able to be executed. So the court didn't issue an order on the question of how it should have been communicated.
How does the United
The lower court just said, I don't like how you did it.
States interpret the order of what would have been enough to comply with this?
I think it's unclear. It's unclear whether he meant that we should have copied Governor Newsom on the email, but he didn't say that. But he agreed with us that, and disagreed with California, that the statute does not contain an approval requirement or a consultation requirement. But at the end of the day, I think that's what the district court imposed by saying you can't issue it through the adjutant. You got to issue it through the Governor Newsom. In which case, what's the point, right? We're going to get to the same place because the governor has no discretion under the second prong of the element sentence of the statute. He shall issue the orders, right? So even if we sent that email to Governor Newsom, we'd get to the same place. He would be required to send that order to the adjutant, and we'd be in the exact same place today.
I understand the United States' argument. There was no technical violation here, but even if there were a technical violation, the remedy imposed by the district court was all out of proportion to the supposed wrong.
Exactly, right? So at the district court hearing, we even asked the district court, if you think there's a technical violation of the statute, give us a chance to cure, right? We'll send the right email, whatever you think we need to do, we can do that. The district court did not give us that opportunity. Instead, the court issued an extraordinary injunction that basically vacated the president's decision, orders him to reverse his order and surrender control over a portion of the armed forces back to the California governor. That is an extraordinary order and remedy, wholly out of proportion. And under the Winter case, really the equities here are totally imbalanced for all the reasons we've explained in our declarations, given the mob violence and the threats that if this order goes into effect, there will be it will be putting lives at risk and federal property at risk as well.
So, counsel, you may not know the answer to this question, and it may not be in the record, but I'm asking about sort of current conditions. As the United States has pointed.
This ought to be an argument. The judge is going to say, well, things have calmed down. It's not a crisis anymore. That's exactly the reason that judges should not be involved in this decision-making, because the circumstances change hour by hour on the ground. What forces are necessary, which ones are not. The lower court judge set an 8-day period for the parties to come back and argue to him again. Obviously, the circumstances on the ground are going to change in an 8-day period. The slow pace of the federal judiciary is completely inappropriate to the management of a riot, looting, and arson crisis in the second largest city in America.
It out. The proposed.
By the way, I think it has calmed down. If it has calmed down, I think it's calmed down precisely because the people paying for the riot, looting, and arson have seen how badly it's being received by the American public and seen how bad it's going to go for them if the courts don't ridiculously bend the knee.
Order that the state asked the district court to impose says in it that the order doesn't prohibit the force from providing indirect assistance to federal officials, protecting federal property, defending federal officials or employees from threatened physical harm, etc. Is right now, are the forces doing materially more than what was in that carve out that the state had proposed?
Yes, Your Honor. And I think that's clear from both the Nell declaration and the supplemental declaration from General Sherman that we submitted just with our reply brief. It explains not only are the guardsmen protecting the perimeter of the federal buildings, but also performing kind of an escort function when ICE agents go outside of the federal buildings. They are setting up a perimeter so those officers aren't assaulted by mobs when they're trying to enforce federal immigration laws. So even that proposed order would have been an extraordinary intrusion as well.
So even if that proposed order had been entered, the United States would, as of now, be doing things that would have been barred by that order.
Yes.
Could these mistakes cost you a comfortable retirement? Fisher Investments is sharing 13.
Okay, thank you.
In your view, is there Is there any issue under the Posse Comitatus Act before us in the current posture of this case?
No, Your Honor. The district court ruled for us on that issue at this stage. In the TRO opinion, I don't understand the state to resurrect that argument for purposes of the stay. I'm happy to address it, but I mean, the point that we made in district court was that there is no violation of the Posse Comitatus Act. The orders are very clear that the guardsmen and the Marines are engaged in a protective mission that falls within the president's inherent power. They're not engaged in direct law enforcement. And I think the declarations from Nell and the other general that we submitted made clear that the guardsmen and the Marines are carrying out those orders faithfully, consistent with statute.
But your view is that there's no need even for us to say that much because the issue just isn't here.
That's correct.
Counsel, did you want to, and I know we've asked a lot of questions, did you want to briefly address, or however long you want to address, the 10th Amendment issue?
Your Honor, I don't think there's much to say because I think it's completely derivative of the statutory question. I think the district court ultimately recognized that at the end of that portion of his opinion. I think the state recognizes that as well. If the president acted consistent with the statute here, then he's acting consistent with the Constitution because the militia clauses authorize Congress to delegate to the president the authority to call up the guard. If he permissibly called up the guard, of course, there's no 10th Amendment problem here.
Yeah, I read the district court's order as I believe you do, where the district court explicitly recognized that if the district court had gotten it wrong on the president's authority to call up the guard, that the 10th Amendment calculus would be materially different and might well weigh in the president's favor.
I think that's right. I mean, there's no 10th Amendment issue here if the president is acting consistent with the statute. I'm happy to answer any further questions. If the court has no other questions, I'd like to talk about kind of the situation on the ground in Los Angeles today and walk the court through some of our declarations, unless the court has any other questions on those statutory issues.
I'm fine with your doing that. And I know Judge Miller and Judge Sung will ask questions if they feel it appropriate, but I'm fine with your turning to that.
Thank you, Your Honor. I just want to emphasize how crucial the Santa Cruz declarations are. It's that the first one is at page 235 of the addendum. The second declaration is attached to our reply brief, and it explains the danger right now on the ground in Los Angeles to federal officers and property from the mob violence and disorder. Paragraph 7 of that declaration, the original one, explains how a violent mob tried to prevent ICE officers from conducting immigration enforcement operations in Los Angeles on Friday, June 6th, immediately prior to the president's invocation of this statute. Paragraphs 9 through 17 then go on to explain an extremely dangerous situation.
So that's important because the Gavin Newsom and the progressives have been trying to argue falsely, of course, that the reason there's rioting, and by the way, the lower judge included this in his TRO order. He talked about this. Well, you know, the problem here is not that there was violence that the National Guard is stopping. The problem is the National Guard was called and that incited the violence. That's not true because the Guard wasn't called out till the 7th, and the violence against the ICE officers conducting detention operations occurred on the 6th, Friday the 6th, and the Guard wasn't called out until the 7th. See if I can find that in the opinion. Let's see. How did the judge? Here it is. Let me share this with all of you. This is from the TRO order that was issued. And here's Judge Breyer talking about this. The Gavin Newsom is claiming one thing you need to claim to get a TRO is irreparable harm. And Gavin Newsom is arguing the presence of the National Guard seemed only to inflame the protesters further. Indeed, local law enforcement arrests jumped after the National Guard was deployed. Trump says, the White House says, that the civil unrest began before Trump nationalized the National Guard. So that's incontestable. But that does not address the governor's point that military presence in a civilian population will worsen and has worsened the situation. Again, this is the lower judge engaging in public policy issues. That's not his place to weigh public policy strengths and benefits. That's for the political branches of government.
Involving violent and riotous demonstrators threatening to breach the federal building in Los Angeles that evening, where ICE was detaining illegal aliens and federal officers were pinned down and severely outnumbered. It also explains how federal officers had to hold the building by themselves because it took over an hour and a half for local authorities to provide support and assistance to the federal officers. Paragraphs 18 through 20 describe what happened Saturday, June 7th, the day the president issued the order. 7 hours of constant fighting nonstop between ICE agents and a violent crowd that disrupted an immigration enforcement operation planned for that day. One officer was trapped inside her vehicle. Another shattered his or her wrist because of concrete blocks that are being thrown, mortar-style fireworks. Paragraph 33 of that declaration, I think, is essential here. It concludes, quote, "I believe the safety of local federal facilities and the safety of those conducting immigration enforcement operations in this area of responsibility requires additional manpower and resources," end quote. That was a week ago. The supplemental declaration confirms the situation on the ground has not changed. There's still ongoing violence and an extraordinary need for the Guard in Los Angeles even today. Paragraph 4 explains that the federal building in Los Angeles, the one that had been breached the week before, has still been closed since June 9th. And again, concludes that the Guard is essential to protecting that property. Paragraph 6, I think, is also crucial. It explains that there are continuing violent protests at federal facilities throughout Los Angeles, including this past weekend. June 14th, there were 1,000 people assaulting law enforcement, a violent mob with rocks, bricks, fireworks, an extraordinary scene. And that declaration concludes in paragraph 7 through 14 that the Guard is essential to continuing to safely enforce immigration laws and protecting federal buildings in Los Angeles. I just commend to the court, it is essential that this injunction be stayed, otherwise lives and property will be at risk. The court has no other questions.
All right, do you want to reserve the remainder of your time?
Yes, thank you, Your Honor.
All right, well.
All right, now we're going to hear from a deputy. I presume this guy is a deputy attorney general for the state of California. Certainly he's representing California side of the argument here. Interesting that the judge on the right, the woman, had 0 questions for the Article 2 executive branch.
We'll now hear for the attorney for the governor in the state of California.
By the way, again, folks, if you want to join me this evening for me live shit posting on X, and I'll pull up my X account right on the screen, just like you're watching these judges right now. We need to hit our super chat goal of 20 super chats of $10 or more, and you're all invited to join me on X. Maybe even make suggestions for what I should post on X. I'll take those under advisement. But this only happens. Join me for live shit posting on X if we hit our super chat goal of 20 $10 super chats. And right now we're at 1. We're 5% of the way there, which is fine. If it's not of interest, it's not of interest. I'll find other stuff to do this evening, but I want to make sure you're all aware of that opportunity.
Good afternoon, Your Honors, and may it please the court, Samuel Harbert on behalf of the governor and state of California. Defendant's motion for a stay pending appeal should be denied. The framers of our Constitution gave Congress the authority to enact statutes governing when the president may call forth a state's National Guard into federal service. The only statute invoked here, 10 U.S.C. section 12406, requires that one of 3 factual predicates exist before that authority may be exercised, and requires that the federalization order be issued, quote, through the governor. But on June 7th, for the first time in our nation's history, Defendants federalize thousands of members of the state National Guard in circumstances where none of those factual predicates exist, and they circumvented the governor, who did not receive the order and who certainly did not issue it. For those reasons, the district court rightly held that the state is likely to prevail in showing that these actions exceeded the proper bounds of executive authority. In each of the equitable factors, counsels strongly against a stay pending appeal, which would allow defendants to prolong this unprecedented, unlawful executive action. To be sure, Los Angeles has seen certain episodes of unrest and even violence in recent days, including violence directed at state and local law enforcement officials. The state has strongly condemned these acts, and it has responded forcefully to them. And I would appreciate the opportunity at some point in my time this afternoon to respond to the suggestion from the other side that the state has been unwilling or unable to respond.
Prada, 2000 runway.
eBay 2025. Dior from eBay.
Back with the baguette.
Fendi, guaranteed.
A stay pending appeal would profoundly injure the state of California and our nation more generally. It would allow defendants to continue diverting thousands of guardsmen away from critical work at the state level, including wildfire prevention and drug interdiction. It would allow defendants to further escalate tensions and the risk of violence in the city of Los Angeles. And it would defy our constitutional traditions of preserving state sovereignty, of providing judicial review for the legality of executive action, of safeguarding our cherished rights to political protest, and of keeping the military.
Counsel, I want to start with one part of the district court's order. And as I read the district court's order on page 23 of the order, I believe it's denominated A283 in the record. I read the district court's order as saying that as long as the president can in some way or manner execute the laws of the United States, that subsection 3 of 12406 isn't met. That although there's no numbers in there, it suggests that if the president can 50% execute the laws, or 70% or 80%, or maybe even 15%, that this isn't met, and that what is required is that the president be wholly unable to execute the laws of the United States for him to be able to invoke the statute. So my first question is, am I reading the district court's order right? If I'm not, please tell me where I'm wrong. And if I am reading it right, does California agree with the district court's reading of the statute?
Your Honor, I'm not sure that the district court's analysis there needs to be read so expansively, and the state is certainly not asking the court to adopt that interpretation of prong 3. All we're asking the court to conclude, at least at this very early stage of the litigation, is at a bare minimum for prong 3 of the statute to exert any meaningful limit on executive authority in this area. It has to mean more than what defendants are suggesting. It has to at least mean that the president comes forward with some attempted justification, or at least an attempt to exhaust or at least contemplate more modest alternatives than immediately reaching the most.
But going back to a case that the United States cites, Martin v. Mott, I mean, one of the things the court said in that case is...
So Martin v. Mott is the Supreme Court case that's been cited by the White House. That Supreme Court case says this question is solely within the discretion of the president, is not subject to judicial review, and the counter argument by the lower court, by the unelected black-robed tyrannical inferior district trial court judge Charles Breyer, his counter argument to Supreme Court precedent that's almost 200, that's 198 years established, was a 2025 injunction ruling by one of these TDS judges engaged in lawfare against Trump over the Alien Enemies Act deportations. And I'm sorry, but an unelected, inferior, black-robed, tyrannical district trial court judge does not trump the Supreme Court.
Is we are all of opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. And the court was including itself in the all other persons. Even if we were to agree with you that there is some limited role of judicial review, how can, with the facts here and the language in Martin v. Mott, how can
look at the demeanor of this female judge? It's just completely disrespectful. It's contemptuous. She looks like every ex-wife listening to her husband explain why she's got to stop spending so much money that they don't have.
that test be met here by the state to justify an injunction against the president's actions?
Your Honor, I'd like to respond to Martin and then also explain why the state believes the modern language of Section 12406 can't support the highly deferential, essentially unchecked view of authority under the third prong of the statute that the government is advancing here.
So the proposed live shitposting on X show for tonight, it's not on X, it's on YouTube. It'll be streamed right here on YouTube on the Attorney Anna Branca show. I'm just going to pull up my X account on the screen like we're watching this video here, and I'll be on X, but it'll all be live streamed here. So if you want to join me for shitposting on X tonight live, we need to hit that goal of $10 or more super chats.
Excuse me. Fanny packs are for summer camp counselors.
You need the new 300.
So as to Martin, it was a very different case. It involved the determination of a foreign invasion. It's also decided many years ago, well before the emergence of modern political question doctrine cases like Zivotofsky, which say that when a court is addressing a core legal issue like interpretation of a statute as here or the Constitution, that is a core exercise of judicial review. It's something that courts have a virtually unflagging obligation to do when they have jurisdiction. And I would add, as to Martin, Your Honor, the government has been making a very similar argument based on that case in the Alien Enemies Act context across the country. And as far as I'm aware, courts have uniformly rejected the government's very similar argument.
These are the what courts have rejected this? It's only been the progressive left, lawfare, TDS, unelected black robe, tyrannical, inferior district trial court judges, because the Alien Act challenges are not being brought in Texas or being brought in Oklahoma. They're being brought in the 5% of the federal district courts where all the liberals are. And of course, they're issuing injunctions left and right against Trump, as no president has ever endured before. That's not lawmaking. Nothing that a district trial court does creates precedent. Only the appellate courts do that.
Invoking Martin in that context, which involves the Alien Enemies Act, which implicates at least something closer to the types of foreign policy or national security considerations that have traditionally led courts not to deem cases justiciable.
So if we were to agree with you that there is some judicial review here, how much discretion, if any, does California believe the president's judgment that this is necessary for him to comply with the take care clause and to take care that the laws be faithfully executed? How much discretion does he have in California's view under this statute in deciding when to federalize?
All right, folks, they're starting to come in. You guys are stepping up to fund this evening's Join Andrew as he shitposts on X Live. I'll be shitposting on X, but that'll be streamed live on YouTube. Lori Peterson stepped up with 10 posts.
Discretion to the two answers. So,
shitposting on X, live streamed right here on YouTube.
Your Honor, two answers. So I do think, looking at the text of Section 12406, it's important to recognize that this statute illustrates Congress knows how to accord substantial discretion to the president when it wants to do so. because it does accord that type of discretion after a federalization decision has been properly made, consistent with the factual predicates in terms of the numbers of troops that the president deems appropriate to respond to the situation that justified federalization. You don't see that language in the factual predicates justifying the initial federalization decision. And it's an established feature of statutory interpretation that when Congress uses language in one part of a statute but omits it in another, courts presume that the omission is intentional. Now,
So does that mean we were, I'm sorry, go ahead. Sorry.
If
Judge
we
Sung.
were writing on a blank slate, I would tend to agree with you. But the problem that I see for you is that Mott seemed to be dealing with very similar phrasing about whenever there is an invasion, then the president has discretion. And it seemingly rejected the exact argument that you're making, and that.
Wow. The female Asian judge is coming in against California. I would not have guessed that.
And
halfway through the oral argument before she said a damn word. Now, some of you would say that's appropriate for a female judge, but don't be misogynistic.
Seem to broadly hold that even with that turn of phrase and that structure of the sentence, Congress was essentially giving the president the authority, the exclusive authority to determine whether the exigency existed. So how do you deal with that?
Your Honor, two very important distinctions with Mott. The first is one I mentioned a moment ago, which is the determination about a foreign invasion implicates sensitive foreign policy.
Right, I understand the factual difference, but what I'm asking for you to address is the textual similarity.
The textual similarity, as we understand Martin, the approach that the court took there was not based on the particular language in the statute. It was based on the sensitive considerations involving foreign policy. And it was a very different context because there you had a plaintiff who was a member of the state militia, a low-ranking member of the military, objecting to a command coming from on high. And courts throughout our history have been reluctant to directly intervene in the chain of command in that manner. But in terms of, Judge Bennett, to get back to the second aspect of your question about whether we see room for any deference or discretion to the president here, we don't have a problem with according the president some level of appropriate deference based upon his experience implementing federal law. The problem as we see it is that there's really nothing.
I got a Mazzaro knife, and what followed was an absolute fiasco. Here's what really pisses me
to defer to here, because the president has not even attempted. Defendants have made no attempt whatsoever to provide argument or evidence that they even contemplated more modest measures to the extreme response of calling in the National Guard and militarizing the situation.
And can I ask you, can I ask you to go back to, I guess the first part of this answer where you were responding to Judge Sung and distinguishing Mott on the ground that it involves, a foreign invasion and a militiaman rather than somebody else challenging it. And, I agree those are both factual differences. But how do you deal with, Luther against Borden, not very long after Mott, seems to have read the opinion in a way that didn't attach significance to either of those distinctions. I mean, that Luther was not a foreign case, was not about somebody in the chain of command, and the court read it for this, fairly broad preclusion of review of the president's decisions about when to call forth the militia. So what do we do with that?
By the way, Judge Sung, the female judge here, was appointed by Biden in 2021. So she's a Biden appointee.
Your Honor, I think that the court sitting today in 2025 should be quite cautious about relying on older authorities in this area, given the shifts over the years in the political question doctrine, justiciability doctrines, but also given the historical development of the strong norm in this country against military involvement in civilian affairs. So cases that predated the Posse Comitatus Act, for example, I think need to be looked at least with some caution before they're too readily or quickly applied to the circumstances of the sort we have here.
But those are maybe good arguments for the Supreme Court to reconsider those cases, but they've told us repeatedly that when there is a case that is directly applicable to an issue, even if we think it's been undercut by later developments and other areas of law or other statutes, as you mentioned, or other Supreme Court cases, we're supposed to follow the applicable case and leave it to them to overrule it. So I guess my question is, what can we as
And this guy, Judge Eric Miller, is a Trump appointee judge, Trump 2019.
The Court of Appeals do with that argument?
Your Honor, I think for one thing, you can look to the other lower court cases around the country that have distinguished Martin in recent weeks and months in the Alien Enemies Act context as persuasive authority. I mean, I also think you can recognize that
So this lawyer for California is actually arguing to the Ninth Circuit Court of Appeals that they should set aside a U.S. Supreme Court decision that's still valid, has not been overturned, because a federal judge in 2025 issued an injunction against Trump. That is insane.
Those older cases you're mentioning did not consider statutory language identical to the third prong of the statute here, or the government's extraordinary argument, which I think really does reduce down to the position that the president can federalize National Guard forces as soon as he makes a judgment that civilian federal law enforcement officials cannot do the job as they've been doing it in ideal circumstances or face any obstacles. Or to put it another way, as we understand the government's position on the third prong, they essentially have a binary view of the world, where there's world A, where federal officials like ICE agents are enforcing the law as they prefer, and then world B, they encounter any obstacle, and then the president can immediately reach for the most extreme possible measure on the table, which is federalizing National Guard troops. As we see it, there are gradations in between those two worlds. And at a minimum, prong 3 requires the president to make a showing that he's at least contemplated alternative, more modest measures before calling in the National Guard.
So counsel, even...
By the way, this judge, Mark Bennett. So on the left, we have Judge Eric Miller, Trump appointee, 2019. On the right, despite his age, we have Judge Mark Bennett, also a Trump appointee, 2018. So it's the upper two are two Trump appointees, and the Asian woman is a Biden appointee, also relatively new. Biden 2021.
If I were to agree with you that the position advanced by the government that there's no review, we're wrong.
This is what she does every time someone comes over.
I've seriously tried everything.
Where in the jurisprudence of the Take Care Clause or the language of this statute is the president, with significant deference at least, required to have judicial review of whether he considered lesser measures? Where does that spring from, even if we were to agree with you that we have some ability to review the president's actions?
Your Honor, as we see it, it comes from the plain text of the third prong of section 12406, which of course is one of the laws that the president has a duty to take care is faithfully executed. And it says unable, not just unable in general, but unable with the regular forces to execute the laws of the United States. And I'd point the court to opposing counsel's definition of regular forces offered before the district court. This is from the district court transcript, which I believe is available on the court's electronic docket.
We have it.
It's that regular forces, quote, means everything other than the state National Guard. It could be local police, it could be federal marshals, it could be the Marines. Now, our position, which I think is really quite modest, is that given the enormous resources and personnel available to the federal government encompassed within that definition of regular forces, there at least needs to be some consideration of whether there are more modest measures than calling for the National Guard before taking that grave and extraordinary step. And in terms of highlighting,
Of course, there's nothing like that. There's no requirement like that in the statute.
Why that step is so extraordinary, why it's been so rare in our history, I'd point the court to the amicus brief filed by high-ranking former military leaders, including former secretaries of the Navy and the Army, former four-star generals and admirals, who have explained the grave threat to the country's democratic traditions of licensing the government to adopt the expansive, near limitless reading of Section 12406 that it's articulated in this case. As that brief explains.
By the way, guess who could always repeal that statute? The legislator. The Article 1 legislative branch can repeal a statute. They can make 12406 disappear, and that would strip the president of this authority. Folks, we're only at 3 of 20. 3 of 20 for tonight's proposed. Have Andrew stream on YouTube that he should posting on any
call forth the net
oral argument.
This poses a risk, makes it all too easy for a president to call forth the National Guard to serve a domestic political policy agenda in a way that threatens to impugn, call into question the historic neutrality, impartiality, integrity of the military in the eyes of the public.
Counsel, that brief seemed to offer a lot of reasons why the president's decision was should have been counseled against, and that they wouldn't have agreed with it, that it's bad for policy, let's say. But I think it stopped short of saying the president couldn't do that, couldn't make that decision.
That's a great point by the Biden appointed judge, Jennifer Sung. So obviously this amicus brief by all these retired generals and admirals and secretaries of the Navy and whatever, that's nothing but political propaganda. They don't get to make this call. They're not the president of the United States. They weren't elected commander-in-chief. They're not even in service anymore. And they don't get to say whether or not the president has this authority. They're basically just whining that there's sand in their panties.
Is there something in that brief that you think was saying the president was not actually able to make this decision?
Yes, Your Honor, in the sense that it highlights the grave consequences of an overly expansive interpretation of Section 120.
Hey, here's a great question from a member, a YouTube member on the Andrew Branca Show. Do all judges have to be lawyers before becoming judges? The answer is no. You don't even need to be a lawyer to be a justice on the U.S. Supreme Court. Now, there may be some like local state laws that have that requirement, but there's no universal requirement that a judge has to be a lawyer.
406, and that should inform the way that the court reads the statute. But that's not the only significant consequence the court should bear in mind. It should also consider the profound effect on our federal structure of government and the balance of power between states and the federal government. Our framers made the decision, it's reflected in the text of Article 1's militia clauses, to generally leave to state governments control over the militia, today the National Guard. What we see is that decision, the wisdom of that decision has endured over the years. And
when can I retire? At Fisher Investments, we know a lot goes into that question, which is
one of the most concrete ways to see that in this case is to look at the declarations filed in district court, which detail the critical functions performed by the California National Guard at the state level. That's central to our claim of irreparable harm in this case of leaving the stay in effect. It's also central to the federalism concerns that we've raised that should animate the court's approach to construing Section 12406. I'd also, Your Honor, to the extent it's relevant.
Hey, we got a couple more super chats. So we got Brad Crawford, a $5 gets out
opposing counsel
for all of you on YouTube.
The court's determination
while I'm on X.
Relevant to the court's determination of the third prong of Section 12406, I'd like to push back quite forcefully on opposing counsel's suggestion that state and local leaders, including law enforcement agents, are unwilling or unable to address the situation on the ground in Los Angeles. think the factual record shows otherwise, including the Santa Cruz declaration that opposing counsel relied heavily on. We would encourage the court to rely on that declaration because I think it really highlights all of the efforts that state and local law enforcement have been making in recent days to respond to the situation. That includes making arrests. I think that the current number is around 1,000 arrests. There are thousands of state and local law enforcement.
By the way, everyone arrested is being kicked loose immediately. It's a complete revolving door. No one's getting charged. No one's getting prosecuted.
Enforcement officers that have been deployed. Local leaders have imposed a curfew in the affected areas between the hours of 8 p.m. and 6 a.m. There are other steps that have been taken as well, including using authority under state law to order unlawful assemblies and disperse crowds as necessary. State and local law enforcement officials are well trained in crowd control and management of civil unrest.
And counsel.
And we see how that's working out, right? Everything is peaceful. Another mostly peaceful protest.
Well, I'm sure that all of your clients subscribe to what you put at page 1 of your opposition to the stay request. To be clear, the civil unrest in Los Angeles is a serious matter. Violence against government officers and property is unacceptable.
Absolutely, Your Honor. And the state and local leaders have roundly and repeatedly condemned this violence, which includes...
They're condemning it from a safe distance. I see someone in the chat mention LA County said they were overwhelmed. They said they were overwhelmed. It's not in dispute. Obviously, one would assume that local law enforcement, LAPD, and the LA County Sheriff's Office doesn't want to see buildings cars burning in the middle of the street, right? Doesn't want to see officers having chunks of concrete thrown at them, their cars destroyed under overpasses, set on fire. How can you say they're in control? It's insane.
Episodes unrest not just directed against federal officials, but against state and local law enforcement officials as well. So it is a profound concern to the leaders of the state, but the state is dealing with it. Local law enforcement agencies are doing their job of dealing with it. And to get back to a suggestion that Judge Miller made to opposing counsel, which I agree with, that in terms of evaluating kind of the baseline when considering an invocation of prong 3 of the statute, it's worth stepping back and remembering that we're talking about federal law enforcement agencies that regularly encounter dangerous conditions in the field when doing their work. And so the question is the delta so significant? Are we in a world that's so different from normal conditions as to just...
The rioters have had federal officers locked up in a federal building for days. They're using garbage dumpsters as battering rams to breach the buildings. How much of that is a normal part of making arrests?
Justify an extreme measure like militarizing the situation and bringing in the National Guard. We don't think that the federal government has even made the first step at seriously attempting to satisfy.
The federal buildings are literally under siege. They are under siege. People cannot come and go. They haven't been able to for days. Is that a normal? That's a small delta between a cop might get injured making any arrest?
That standard. If I could, Your Honors, I'd like to turn to through the governor requirements that the district court also applied. We acknowledge that there is some ambiguity in the meaning of this requirement.
Thank you, DWS. Contributes to tonight's proposed Join Andrew live on YouTube as he live streams shit posting on X. Now we're at 6 of 20, getting a little closer. Our frame.
What the federal government suggests, but
man, I appreciate it.
But we don't think it can credibly mean what the federal government suggests, because what that suggests is that while the Congress in 1908 added this language, it can be satisfied according to defendants by not involving the governor in any way, shape, or form. And then at the end of the process, when the decision is made, when the final document is issued, to just slap a label saying through the governor at the top of the document.
What is the, no, go ahead, Judge Miller.
Now, that is an intellectually dishonest argument that the lower judge made too. The lower judge said, well, Trump's arguing that all he has to do is slap the words ordered through the governor on top of the paper, and he's all good. Let's see. Here we go. Let me share this with you from the TRO order. The lower judge said that Trump asserts that he complied with 12406 because written at the top of the June 7th and June 9th Department of Defense orders, it says, through the governor of California. True enough. True enough. But the interpretation of 12406 that permits the president to federalize the state's National Guard by typing the phrase through the governor at the top of a document that the president never sends to the governor strains credibility, especially given that Congress specifically amended the statute to add the requirement shall be issued through the governor. This is an intellectually dishonest argument because it's a straw man argument. Trump only mentions in passing that they put the words on top of the document, but that's not why he's saying he satisfied the statutory condition. Trump says he satisfied the statutory condition not by only putting some words on the top of the paper, but by issuing the order through the California National Guard Adjutant General, who by state law is the officer who executes this function for the governor. That's why. So this guy's being just as intellectually dishonest as that judge.
You see this house in Florida? Well, let me show you how I invested into it with just a few $100s.
What is your understanding of how it's supposed to work? So if the president, I guess, or the Secretary of Defense, writes up the order, sends it to the governor. If the governor then, looks at it, says, this is interesting, sticks it in his drawer, and goes out to lunch, what happens then?
Your Honor, I want to highlight just how far we are away from that.
I understand, and I'm not.
No attempt.
When it's advantageous to California, they want to talk about all kinds of Chicken Little, the sky is falling hypotheticals, speculative hypotheticals, but they don't want to address them when it's contrary. Like what would have happened if Trump gave the order, literally handed it to Gavin Newsom? How would we end up in a different place? What would be different?
In good faith,
comply with it.
Anyone in the state, just hypothetically.
Our position is that the best understanding in light of our general expectation in our system that
there's only two possible answers here. Either there would be no difference because the governor has no discretion. The order simply goes through him like shit through a goose, or so we'd end up in the same place. The guard would have still been ordered. They would have been activated. Or the alternative answer is that Governor Gavin Newsom has a veto power over Trump's authority under this statute, which the statute does not say at all, not a word to that effect.
When Congress seeks to involve government officials, it seeks to promote rather than undermining federalism and state sovereignty. So we think the best reading would be that the governor's consent is required, but we don't think
the governor's consent is required. So they went the second way, completely unsupported by the statute. By the way, I'm very pleased to see that support is also coming in for our proposed Join Andrew on YouTube. I think we got two special support protecting the right girl with aggressive in 15 minutes. She should be
hard to agree with us that there was a violation.
There's no question about it. Lots of people should be arrested. All right, back to the oral argument.
Court needs to go nearly that far to agree with us that there was a violation here, because at a minimum, we think that issuance to the governor requires notifying the governor of the federalization decision and asking him to issue it, which would give the governor a chance to consult, at least consult on the scope of the
So where does the statute say that issuing it through the governor requires either the governor's consent or requires consultation?
Bam! Bam! This was the aluminum baseball hat to the head of this Deputy Attorney General of California, because you'd have to completely fabricate that position that this statute requires any kind of consultation or consent from the governor.
With the governor. Where in the text do you take that from?
Your Honor, we take it from the plain meaning of through the governor. So that's the first step. What does it mean to be issued through the governor? For the governor to issue it, we think at a minimum that means that the governor needs to be informed of it and given the chance to issue it. And here's why we think that the statute should be read to include at least a consultation opportunity. Because
it's such weak. What a feminine approach. It's like a kindergarten approach to statutory interpretation. It doesn't say that the president of the United States, the Article 2 executive branch commander-in-chief of the U.S. military, it doesn't say he has any obligation to consult. But wouldn't it be the nice thing to do? Just give Gavin a call on the phone. That's all you had to do, President Trump, which, by the way, he did. and Gavin denied it. But why can't you just at least ask how Gavin feels about this?
Defendant's contrary view would pose very serious constitutional questions. So under their view, they can just do the whole process without consulting the governor at all and then slap his name at the top of the document at the end of the process. That risks blurring the lines.
Again, the slap the name thing is completely intellectually dishonest straw man argument.
The political accountability in much the same way as the commandeering laws that were struck down by the Supreme Court in cases like Prince and like Murphy. It essentially forces.
Again, completely intellectually dishonest. So commandeering would be if the president sought to take, for example, he sought to federalize the LAPD. That would be the federal government commandeering a state resource. That's not allowed. That's not allowed. But when the president federalizes a state National Guard, they're no longer a state National Guard. Now they are a federal National Guard. There is no commandeering. Trump's not ordering about state employees. Once they're federalized, these are federal military assets.
The governor to share in the political responsibility for.
So if we were to disagree with your reading and looked at this as a ministerial task that's in the statute, would there still have been more that the United States would have been required to do other than sending this to the adjutant, who is the governor's subordinate and issues all orders in the name of the governor? Would there have had to have been?
All right, this guy's definitely on Trump's side.
And something directly to the governor's email or mailed? I'm not trying to be facetious here, but if we disagree with you about consultation and consent, was there anything more that needed to be done here as a technical matter, in your view?
But if you want to rebuild your joint cartilage, don't take standard collagen. This is why.
In our view, yes, Your Honor, to issue it through the governor, it needs to at least go to the governor. But if I could, I would like to take one more pass at persuading you that the federal government's interpretation just can't be right. As I understand it, they do present it as a purely ministerial requirement, essentially a routing requirement to ensure that there's not command confusion in.
That is the correct answer. That interpretation, which is not his interpretation, he's restating Trump's interpretation. That is the correct interpretation. The through the governor language is simply to ensure a smooth transition of the chain of command from state authorities to federal authorities.
The event that the state guard is transferred to federal authority. The reason we don't think that can be right is there are other federal statutes, most notably the Insurrection Act, which similarly allow the transfer of the National Guard to federal authority and pose.
By the way, the Insurrection Act is next. If this falls through, Trump's next step is the Insurrection Act, which also authorizes him to federalize the National Guard without the permission of the governor And it also suspends posse comitatus and allows the activated military to serve as a law enforcement function with powers of arrest and all the rest of it, which should scare the crap out of California, because then Trump can send the entire U.S. military into California and clean out tens of millions of illegal migrant third world invaders like that. Everyone becomes an effective ICE officer. Every soldier, every Marine, everybody becomes an effective ICE officer.
Pose the very same types of chain of command confusion the defendants have highlighted here. Those statutes do not include the same through the governor language. So Congress would have had, it must have had something else in mind when it deliberately chose to add this language to the statute.
By the way, I guarantee you these judges are thinking about it. These judges are well aware that if they deny Trump here, Trump has a Trump card. And that Trump card is the Insurrection Act, 10 U.S.C. Section 253. That's the big artillery. And Trump is trying to, kind of baby step this. But if they deny him the baby steps, Trump is not going to sit back and watch his ICE officers in L.A. get murdered and watch his federal buildings get burned to the ground by these progressive fascist and illegal migrant third world invader rioters, looters, and arsonists. Trump is not going to do that. These judges know that, and he doesn't have to do it because he has the Insurrection Act in his next level.
Consultation. They wanted,
in 19,
of imposing a consultation. They wanted,
in 1908.
And if they wanted, it's a very roundabout way. Of imposing a consultation requirement. It seems like on your reading, they should have said, orders for these purposes shall be issued after consultation with the governor or something like that. This is a very indirect way of accomplishing that purpose, if that was the purpose, isn't it?
Not so sure it's indirect, Your Honor. I think when Congress imposed an issuance through the governor requirement, they were contemplating good faith on both sides and that there would be some level of coordination involved.
We're supposed to be mind reading the words consultation into the statute, which I can assure you, here's the statute. This is it. This is what we're talking about. 10 U.S.C. 12406. The word consult does not appear. Let me do a word search. Consult. It doesn't show up on your screen. Sorry about that. 0 out of 0 occurrences. It does not occur. No synonym of consult occurs. This is all nonsense. And we are now up to 11 out of 20. Whoops, that's not what I wanted. This is what I wanted. For again, if someone puts in 30, I'll count it 3 times.
And just one more point on this as evidence that our reading of the statute is correct. I'd actually point you to the president's memorandum on June 7th itself, which directed Secretary Hegseth to, quote, coordinate with the governors of the states. That suggests that even the president saw this statute as imposing some type of consultation or coordination requirement. Of course, Secretary Hegseth did not do so.
And what about, Judge Bennett alluded to this.
Hey, this is a big one. I got to pause it to share it. This is a huge one. $50 from Peter Watkins. I will count that 5 times towards the goal of 20 $10 super chats and tonight's. I hope it'll be infamous. I hope I don't end up getting banned from X. Tonight's proposed.
You're not a child. You're a man. So stop wearing so many layers to go outside and get the new 340 GSM military-grade bearskin tactical hoodie. The 10-pocket tactical fleece hoodie that...
Join Andrew as he shit posts on X live here on YouTube. I will short
or provision of state law.
Close this deal. We have 9 minutes.
Provision of state law a moment ago, but just as a general matter, under principles of agency law, if you have to notify someone or get someone's consent or do something through someone, that means someone or that person's agent. And here, I guess the Military and Veterans Code, Section 163 of state law says that the Adjutant General can issue orders in the name of the governor. So it would seem like the state has made the Adjutant General effectively the substitute for the governor in this context.
This judge is also a Trump appointee.
So why wasn't it enough that they sent it to that officer?
Your Honor, that's not our understanding of that provision of state laws. We understand that the Adjutant General still has an obligation to communicate and coordinate with and take orders from the state's chief executive and the commander in chief of the armed forces under the California Constitution with respect to the National Guard. It's just after those decisions are made, the Adjutant General has authority to issue orders in the name of the governor.
That's not how agency works. Anyway, John Smith, $10. Thank you very much, man. I really appreciate that. We are getting a little bit closer every time. It's funny how the super chats always come in the last 10 minutes of the show. I'm not being critical. I really, really appreciate the support. Edwin Jones, $10. We're down to.
So we don't read it in the expansive way that our opponents do.
All of his duties under Section 163 are as prescribed by the governor, and he shall issue all orders in the name of the governor. And this is a statute that's been around for a while, yeah?
This guy, this older guy, also a Trump appointee.
It has, Your Honor.
Oh my God, did you see the poor judge, what's her name? Jennifer Sung was just pinching her nose like she can't believe she's going to have to vote in favor of Trump here against these ridiculous arguments. Let me see if I can rewind it just a little bit.
All of his duties under Section 163 are as prescribed by the governor, and he shall issue all orders in the name of the governor.
You see her nodding her head? She's like, yeah, that's the winning argument. I look how unhappy she is, though. She looks like she just found out her ex-husband married a younger woman.
And this is a statute that's been around for a while. Yeah.
Oh no, she's not. I guess she's just picking her nose. I thought she was like pinching the bridge of her nose, like she couldn't believe what she's going to have to do.
Yeah.
It has, Your Honor, and as I mentioned, we don't read it as the federal government does. I'd also point out, just because that state law may give the Adjutant General certain authorities, that doesn't mean that the president has certain authority to issue orders through the name of the governor under federal law. And we know from the plain text of Section 12406 that Congress knew how to allow orders to be issued through a commanding officer, because that is the process prescribed with.
It could be it could be a no tie shit posting night, but not for $200. My sweet wife Emily would insist on more than $200 for me to be no tie.
But that
with respect to the National Guard of the District
guy. It's a good suggestion.
With respect to the National Guard of the District of Columbia.
But that prescription is federal law.
It is, Your Honor.
The DC prescription. I take the reason they mentioned that there is because that is a matter of federal law over which the Congress has control.
My point is simply that the text illustrates that Congress knew how to allow an order to be issued through a commanding officer instead of a chief executive, and it didn't do that with respect to the governors of the 50 sovereign states.
Counsel, I want to go back to the what you're arguing in terms of the conditions necessary for the president.
This judge is a Biden appointee, 2021 Biden appointee.
To exercise its calling forth power as delegated by the statute. I hear you arguing that the exigency required under subsection 3, essentially the inability to execute the laws with the regular forces, wasn't met. I don't hear you arguing that the president cannot rely on that subsection based on anything it said in the executive order, or that it wasn't properly invoked or relied on I hear you arguing that we can't.
Guys, we made it. We did make the threshold. I will be doing this show tonight. Thank you. 8 and there might.
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device. Here's what changed in just 2 weeks. In the
Oh, darn it. Sorry. I know where I was, though. I was right about here. Here we go. I was right about here. Whoops. It was 8 minutes. Here we go.
Essentially the inability to execute the laws with the regular forces wasn't met. I don't hear you arguing that the president cannot rely on that subsection based on anything it said in the executive order, or that it wasn't properly invoked or relied on. I hear you arguing that we can and should consider the evidence put forth before the district court, not that we would be limited to what's in the executive order. So are you conceding those points?
So one of the things that the lower trial judge did that was so contemptible was he looked at the executive order from Trump and he said, but Trump's not providing all the evidence I would want to see in the executive order, as if the executive order was intended to introduce evidence in court. The evidence is in the real world, and the judge wouldn't look at it. So this judge, Jennifer Singh, who's a Biden appointee, is asking California, are you seriously telling us that we're not allowed to look at reality? We're not allowed to look at what's actually happening? We have to pretend that Trump's executive order is the only relevant evidence in this consideration?
I understand the question. I certainly acknowledge that, yes, the district court should have been looking at the evidence put forward by the federal government to try to satisfy the factual predicates required under Section 12406. And as the district court rightly concluded, the federal government had failed to provide argument or evidence that would even really make a serious attempt at satisfying that predicate, because it didn't even suggest that it contemplated more modest measures than calling in the National Guard.
I'll try to clarify my question. You are not arguing that we would be limited only to what was stated in the executive order to determine whether the factual basis is there. Is that correct?
I see. That's correct.
And you're not arguing that the executive order failed to rely on subsection 3 or invoke subsection 3.
These are not questions. The Biden appointed judge is not asking questions that are helpful to California.
Is that correct?
That's not an argument that we've made, at least at this preliminary stage of the litigation. That's right. Although I do think it's notable that the federal government has principally relied in its papers and in the executive order on prong 2, which I do think suggests that they understood they didn't make a serious effort to show evidence or argument as to prong 3.
Well, probably because the federal government, having its ICE officers relentlessly attacked and under siege inside a federal building, maybe they think it's self-evident that these ICE officers are unable to execute the laws with the ordinary resources.
Okay.
Your Honors, with permission of the court, I know that I've gone past my time. I would like to very briefly address irreparable harm.
That's fine, counsel. Please do so.
Thank you, Your Honor.
5 minutes.
We would ask the court to reject the government's motion for a stay pending appeal, because every day that the stay remains in effect, it causes these 2 principal forms of irreparable harm that I'd like to highlight. One is the concrete harm to important state functions that are not happening because of the diversion of now fully 1/3 of California's National Guard troops that are available to the president's unlawful mission on the streets of Los Angeles. That's causing harm in terms of not having troops on the ground ready to respond to emergencies, especially wildfires, which is especially problematic as we enter the peak of wildfire season, which experts believe is likely to be especially harmful and severe this year. The ECK declarations, again, just briefly, Your Honors, detail the many important functions beyond wildfire prevention, emergency response, drug interdiction performed by our National Guard units when they're not federalized. Beyond that, every day that this order remains in effect, it is causing harm to our nation's broader democratic tradition of separation of the military from civilian affairs. And that is not just a problem for the 60-day presumptive deployment here, which could be extended further by Secretary Hegseth. It's a problem because it sets a precedent for this president and future presidents to take similar actions going forward. And in closing, Your Honors, in considering the legality of the president's actions and the request for a stay, it's important to bear in mind the sheer scope of the president's order here. We've been focused today on the conditions in Los Angeles, but the order is not limited. The president's order is not limited to Los Angeles or even California.
And why would it be? Why wouldn't be when these progressive Marxists are rioting and looting, are doing all these things in major cities all over the country? They're impeding ICE's ability to enforce the nation's immigration laws through riot, looting, and arson, not just in LA. So why would Trump's authority to fight this rebellion and attacks on his federal law enforcement officers, why in the world should it be limited to LA when it's happening in many places? What an inane argument.
There's no limit in terms of geography whatsoever. It's not limited in the number of troops that can be called up. It's not limited in the duration that those troops can be called up for. And there is no real limit imposed on the scope of the mission. It's not limited to assistance with ICE enforcement. It also allows for protection of, quote, other U.S. government personnel who are performing federal functions. That's essentially anything the federal government is doing. That is staggeringly broad in scope. In the state's view, it is plainly unlawful, inconsistent with our nation's traditions. We would respectfully ask the court to deny the government's extraordinary motion for a stay pending appeal.
All right. Thank you. Mr. Shumate, you have time.
Of course, it's the TRO that is extraordinary. By definition, injunctions are extraordinary remedies not normally given. Asking for the stay is not extraordinary. It's the TRO itself that's extraordinary.
Time left.
Inflation doesn't retire when you do. Rising costs and living expenses impact the income you'll need.
3 minutes.
Thank you, Your Honor. If I may, I'd like to make 3 quick points in rebuttal, and I want to start first with the Martin
So this, of course, is Trump's Department of Justice lawyer
case, which there's some discussion of that case. The point I want to make is
he's going to go back to Martin. I want to rewind it a little bit to so we can start with him. Martin is the 198-year-old, still valid law Supreme Court decision that says these judgment calls are solely within the discretion of the president. And the only countervailing legal authority that California has been able to bring to bear against a long-standing Supreme Court decision are injunctions issued by lower, unelected, black-robed, inferior district trial court judges engaged in TDS lawfare against Trump. A district trial court judge, his decisions create no precedential authority. They're not binding on any other court. But that's all California has to bring against the U.S. Supreme Court itself. It is pathetic.
Mr. Shumate, you have time left.
Oh, that's Shumate. I didn't know that's who that was. Shumate does a lot of appellate briefs for the White House. He's a very, very smart lawyer. Very smart lawyer.
Thank you, Your Honor. If I may, I'd like to make 3 quick points in rebuttal, and I want to start first with the Martin case, which there's some discussion of that case. The point I want to make is that that decision is both controlling and it remains good law. It's
Yep. Sir, just because it's 198 years old doesn't mean it's not good law. It's younger than the Constitution.
controlling because the statute in that case is very similarly structured to the statute at issue here. The Act of 1795, again, started with a wherever clause, and it had one condition, invasion. And if that condition was met, the president could call forth the militia. Here, the statute also starts with a whenever clause. It also includes the invasion prong, but it also has two additional elements. And it concludes with a delegation to the president that he may call forth the guard if in his judgment it's necessary. So I think in deciding a reviewability question, you look at the language of the statute, not factual distinctions on the ground. Yes, in that case, it was an invasion, it was a foreign policy matter, but this statute also, that's before you hear, Title 10, also invokes foreign affairs powers and the president's domestic powers as well. And it's also remains good law, right? We cited the Dalton case, which was a 1990s decision that invoked the same principle, where a statute is drawn in a way that delegates broad discretion to the president. Courts don't just defer to the president's judgment. Courts don't review the president's judgment. And that's what we have here. And in that case, it was a domestic matter, not a foreign policy matter. So Martin would not be just limited to foreign policy matters. The second point I wanted to make was the easiest path to a decision here is on the third problem. The president made a determination that he is unable, based on with the regular forces, to execute the laws of the United States. The record certainly bears that out, not only in his proclamation, but also in the declarations made clear.
I don't disagree with this observation, but that judge in the upper left is a Trump-appointed judge.
The plaintiffs have conceded there is civil unrest in Los Angeles, but not just ordinary civil unrest. Civil unrest that is targeting federal law enforcement officials and designed and aimed to prevent them from carrying out their duties. The court should at least defer to the president's judgment under prong 3. And then finally, on the through language, I think the plaintiffs have an extraordinarily dangerous interpretation of that statute. Under their reading of the statute, Governor Newsom could pocket veto the president's orders, not convey them, and wait for somebody to come down to Sacramento and consult with him before he issues that order. That is not what the statute says. The statute says through the governor, doesn't say by the governor. We've cited other statutes that are similar that contain the consultation language. This statute does not contain that language. In sum, Your Honors, we would ask you to grant our motion for a stay pending appeal. If you deny our stay pending appeal, we would ask the court to give us an opportunity to seek emergency relief from the Supreme Court. Thank you.
All right, we thank all counsel for their helpful arguments, especially on an expedited basis. We thank counsel for appearing remotely. I would also simply note that the panel is cognizant of the fact that you have another hearing set on Friday before Judge Breyer. And again, thank you. And with that, the court is adjourned.
So the Judge Breyer, although his TRO was frozen by this by this 3-judge panel of the Ninth Circuit Court of Appeals, Judge Breyer has decided that even though that's frozen, he's still going to go ahead with as if he has jurisdiction over this with his evidentiary hearings. And the next hearing happens 2 days from today on Friday. So I expect this Ninth Circuit is going to issue the response before that happens. Of course, that Judge Breyer should have nothing to do with any of these issues. This is, of course.
So this right here, so this argument right here was 3 months ago. This argument right here was 3 months ago, on June 18th. I think it was after they had the No Kings riots. After they had the No Kings riots. I think that was around June 8th or June 7th. Looks like that they did this on June 18th. So this was the first appeals from California. California and Trump going at each other about if National Guard if he can order National Guards in California. So the next one is the hearing that they had today, and today is October 9th, 2025. And so the first one was talking about LA. This one is talking about Portland. So the first one was the California Attorney General was arguing against Trump administration. Now we have the Oregon Department of Justice arguing with the Trump administration. And we supposed to get into this. Make sure that you're pulled up and rolled up. You know, I'm so glad that you showed up. To comment, like, subscribe, tell a friend, and do it again.
Maybe we'll get right back.
A little faster than they actually do. Here we go. We'll hear the clerk first.
Go.
The judges of the United States Court of Appeals for the Ninth Circuit. Hear ye, all persons having business with the Honorable, the United States Court of Appeals for the Ninth Circuit will now draw near. Give your attention and you will be heard. For this court is now in session. God save the United States and this honorable court.
Amen.
Welcome to the Ninth Circuit. Judge Beatty and Judge Graber and I are glad for your timely appearance. And we know this is on a quick turnaround and we appreciate all the hard work that's gone into it. We're ready to proceed with argument in State of Oregon, City of Portland versus Donald J. Trump, case number 26-6268. We'll first hear from Mr. MacArthur.
Thank you, Judge Nelson, and may it.
All right, so that's MacArthur. That's the DOJ lawyer on the right. And they're hearing from him because it's Trump appealing this TRO to the Court of Appeals. So they're the plaintiffs, what we would call the appellant here. And the state of Oregon and the city of Portland are going to be the respondents.
Please the court, Eric MacArthur for the federal government. I would like to reserve.
My God, do you think that's what that guy's voice actually sounds like?
3 minutes for rebuttal, if I.
Is that room he's in full of helium?
May. For the second time in.
All right, I got to slow it back to normal speed. I got to see if that's how that guy talks normally.
Trump, case number 26-6268. We'll first hear from Mr. MacArthur.
Thank you, Judge Nelson, and may it please the court, Eric MacArthur for the.
Oh my God, that's just his normal voice. The Department of Justice hired Mickey Mouse. Good Lord.
The federal government. I would like to reserve 3 minutes for rebuttal, if I may. For the second time in recent months, a district court in this circuit has entered a heretofore unprecedented order enjoining the president from calling up the National Guard to protect federal personnel and property from violence aimed at thwarting federal law enforcement.
So that's an important point, right? The National Guard's not being called up to be police, to carry out traditional law enforcement functions. That would be a violation of posse comitatus in the absence of something like the Insurrection Act. But federal forces are allowed to be used to protect federal personnel and property. Always have been, always will be.
The first order was swiftly stayed by this court, and this order should be swiftly stayed as well. For months, the ICE facility in Portland and the federal law enforcement officers who work there have faced a steady stream of violence, threats of violence, and harassment from violent agitators bent on impeding federal immigration enforcement.
Counsel, I'd like to ask a couple of questions.
That was quick. So this is the 76-year-old Clinton appointee asking this.
And I would appreciate having other counsel answer the same questions when it's their turn. And my first question is, what document is the declaration pursuant to section 12406? Is that the June 7th document signed by the president?
So I think there are a series of writings that the court can
So 12406 is the statutory authority that Trump used to activate the National Guard. And it allows it's a permission from Congress. So, military affairs are shared between the two political branches of government, the Article 1 legislative branch, the Article 2 executive branch. The Article 3 judicial branch should have nothing to say about any of this. But in this case, Congress delegated to the president a portion of their authority over the activation of the National Guard. And Congress said the president has the authority to activate the National Guard under 12406, Statute 12406, if there's a foreign invasion, that doesn't apply here, or if the president's unable to otherwise enforce federal law, arguably that is the case here. And, suddenly I'm blanking on the third provision. Let me pull it up real quick. Or if there's a rebellion or danger of rebellion to federal authority, which also clearly is applying here. So there's no foreign invasion, but the rebellion or danger of rebellion and the unable to carry out federal law are obviously at play here.
Up to here, the first point that I would make is the statute doesn't actually require any writing, contemporaneous or otherwise, in order for the president to be able to invoke this statute. But there's the June 7th.
I'm a little nervous because I have no clue what's about to happen, but this could either be a total disaster or the world's greatest magic.
So that's an interesting point, because sometimes Congress passes these military authorization statutes and they do require something in writing from the president. So like the Alien Enemies Act from 1798, John Adams signed that into law after it was passed out of Congress, President John Adams. The Alien Enemies Act requires a proclamation by the president that he's triggering the Alien Enemies Act. Statute 12406 does not have that requirement. So this judge is asking, well, what's the writing that's the basis for this triggering of 12406? The lawyer says, well, we're not required to have one, but there's a collective series of facts that justifies it.
Memorandum. There is the post on Truth Social on, I believe it was September 27th, stating that the president was responding to a request that had been made by the Department of Homeland Security. That's another document the court can look to, is the document that the Department of Homeland Security sent requesting assistance in.
By the way, all these judges in their official photos, well, the two on the left, what how did they pronounce Bede on the right? She's just got blonde hair, I guess. But the two judges on the left, they both have dark brunette hair in their official photos. that doesn't exist anymore. Hey, listen, I'm sympathetic. My hair used to have color too.
Portland. There are further posts on social media in early October, further explaining the president's basis for the decision he made in late September. And then last, there is the recent memorandum activating the National Guard in Illinois, which also references the basis for the activation in Portland.
My second question is, under the second prong of that statute, what is the meaning of a rebellion?
So the meaning of rebellion would be the plain meaning of that.
You guys are not going to believe this, but when I was a kid, I had bright orange hair. Bright orange hair. In fact, my dad worked for the government as a map maker. And when I was a kid, we lived in a Airstream trailer because he was out west. You ever see those brass medallions that are put into the ground as markers for mapping purposes?
Was enacted. That term that existed at the time this language was enacted. It was enacted in 1903.
Surveying. That's what I meant. Survey markers.
And so there are contemporaneous dictionaries. I think one defined the term to mean a deliberate, organized resistance by force and arms to the laws and operations of the government. That's from Black's Law Dictionary in 1891.
Counsel, can I ask about that? You're right that the current law was 1903, but it goes back to 1792. I mean, it seems like rebellion in this series of statutes would have a sort of developed meaning, would it be improper to go back to earlier dictionary definitions or historical examples in analyzing the meaning of rebellion?
Oh, I think that would be perfectly proper, Justice Nelson, to look historically how the term was understood and what are the historical examples in which that language had been invoked to call it the Guard. And the key example here is, of course.
So, two of the arguments being made by the anti-Trump forces are that when the statute says you can call out the National Guard in cases of rebellion or danger of rebellion, the rebellion, they say, has to be an attempt to overthrow the entire U.S. government, not just some particular function of the U.S. government. That's obviously nonsense, because the first president, George Washington himself, made use of the pre-statutory form of 12406 to put down the Whiskey Rebellion, and that applying almost exactly the same legal language. And the Whiskey Rebellion was merely a rebellion against a whiskey tax. It wasn't an attempt to overthrow the government. So that's obviously nonsense. The other main argument that the anti-Trump forces are using here has to do with unable to enforce the laws, federal laws. And they say, well, you know, if the president's able to enforce any portion of the law, well, then he's not unable to enforce the law. So if he tries to enforce the law 100 times and he's foiled 99 of those times, but successful once, that one success out of 100 means he's able to enforce the law. In fact, the standard should be the opposite. If the president tries to enforce the law 99 times and once he's unable to do it because of violent conflict, opposition, that is him unable to enforce the law.
Here's a brand new, better way to sell your house. So if you're thinking about selling anywhere in or around the Edmond area, including the blue areas on this map.
Of course, the Whiskey Rebellion, which refutes the basis on which the district court held here that there was no coverable factual basis for the president to conclude that there was a rebellion or danger of rebellion, because the court said there was no basis to conclude that any violence in Portland was aimed at overthrowing the entire federal government. Of course, no dictionary definition of the term rebellion requires that it be aimed at overthrowing the entire government. That wouldn't pick up historical circumstances like the Whiskey Rebellion. And I think it would lead to some pretty untenable results. For example, if you had a state governor who activated the National Guard and ordered them to shut down every ICE facility in the state, the president couldn't say that's a rebellion against the authority of the government and activate the National Guard, because that's not aimed at overthrowing the entire government.
My next question is regarding the third prong of the statute, and what is your view of the meaning of the phrase "the regular forces"?
So that third provision says the president can call out the National Guard if he's unable to enforce federal law with the regular forces.
So I think the regular forces are the forces that ordinarily enforce the laws that are at issue, and that the president has concluded the regular forces are unable to enforce. Here, I think that would be the officers of the Department of Homeland Security and Federal Protective Service.
Does that include local officers, local police officers as well, or only the federal officers?
I do not think that would include state and local officers. They are not charged with executing federal law. I think this is a statute that's solely focused on the federal forces that are at the president's disposal to execute the laws.
I just want to follow up on that. The section that immediately precedes 12406 is, of course, 12405, which appears to conjoin regular forces as meaning the Army or the Air Force. And there is from 1902, there's a Supreme Court case that appears to define the regular forces as the National Standing Professional Army.
So I would just point out, this is the first time I'm hearing this argument. So this was the notion that the regular forces in 12406 refers to the Army and Air Force. First of all, there was no Air Force. I mean, what was the Air Force? That was after World War II. So it certainly wasn't around at the time of George Washington and the Whiskey Rebellion. But it's interesting because she's bringing up what's essentially a new argument in favor of the TRO that was never mentioned by the judge who issued the TRO. When this happens in reverse, when Trump wins at a certain court level, and then the other side appeals and Trump tries to introduce a new legal argument, the courts say, well, sorry, Trump, you waived that legal argument when you didn't raise it in the first place. We're not going to hear new arguments now. But now this Clinton judge, I wonder who sent her this argument. Which left-wing NGO group of lawyers sent her this argument that was not made at the trial level, and she's just raising for the first time here?
What precedent would give it a broader meaning than that?
I'm not sure. It does have a broader meaning. I suppose it could be broader or narrower, but no one here has made the argument that the president has to first bring in the Army, the Marines, or the Air Force, the actual armed forces, before calling up the National Guard. That was, of course, not the case in Newsom, where the panel held in a published opinion that subsection 3 of the statute was satisfied. And I think that would be pretty extraordinary to say that the president has to use the actual armed forces before calling up the National Guard. For example, President Nixon did not do that when there was the postal strike, and he relied solely on section 12406 to activate state National Guards to execute postal laws. That I think would be inconsistent with historical precedent as well.
Can I ask about you brought up the Nixon example. What was the basis for enforcing the laws of the United States? You mentioned postal laws. Are there laws that require mail?
By the way, of course, Eisenhower, I believe it was Eisenhower, right, called out the National Guard to enforce school desegregation in Little Rock, Arkansas. Here the National Guard is advancing on protesters against school integration at the point of a bayonet. The guy in the foreground here, in the white t-shirt, short sleeve shirt, he's touching his arm like he already got pinked by a bayonet. I can assure you, the normal U.S. military forces were not called out before the National Guard was called out here. If they had been, this would be all over. Because there was never any armed resistance, so as soon as you have a dozen guys show up with rifles and bayonets, it's all over.
At Fisher Investments, we know a lot goes into that question, which is why we've made this quick and easy plan.
To be delivered in a certain time. What were the laws that were at issue there?
That's my understanding.
I want to rewind it a little bit.
Example. What was the basis for enforcing the laws of the United States? You mentioned postal laws. Are there laws that require mail to be delivered in a certain time? What were the laws that were at issue there?
That's my understanding and my recollection of the executive order there was that President Nixon enumerated certain laws relating to the Postal Service and said that because of the strike, those laws could not be executed. And that was the basis for federalizing the National Guard.
And my next question, which is again for all parties to address, I hope, and that is, what types of evidence are relevant in determining whether there is a colorable factual predicate? And specifically, I'm interested in how non-local evidence is relevant. Why is it important to know what happened in Los Angeles, Dallas, or Chicago when dealing with Oregon? And also remote in time. The recent Newsom case dealt with events that predated the declaration by a day or two. So what relevance does evidence have that's remote in time?
So to address the first part of your question, Judge Graber, I think the key evidence in this case.
So let me address this real quick. Wouldn't someone who sorry,
and Judge Graber
is the declarations that we submitted below and
And Judge Graber and I.
From earlier.
Chicago when dealing.
Sorry, I messed up the timeline there, but I got it right, pretty close to where it was. So now she's asking, well, what evidence should we be looking at in deciding whether or not the president has a colorable factual basis for calling out the National Guard? The correct answer, in my view, is you, Judge, should not be looking at any evidence. It's not your call to make. It's the president's call to make. As long as there's more than 0% evidence to support the president's decision, he's commander in chief. And there is more than zero. He cited evidence. But she's trying to say that, well, you know, what happened in California is not relevant to Oregon. What happened in Dallas, Texas, the shooting from the rooftop into the ice garage, is not relevant to Oregon. But of course, if you're the president and you're facing a cohesive, organized opposition force like Antifa resorting to violence, wouldn't it be more pressing if they were resorting to violence in more than one location within the country? Wouldn't the previous acts of violence by the same organization allow for a reasonable inference that unless we check them in Oregon, we're going to have the same kinds of violence? If anything, those events in other regions would reinforce the need to activate the National Guard in Oregon.
With Oregon, and also remote in time. The recent Newsom case dealt with events that predated the declaration by a day or two. So what relevance does evidence have that's remote in time?
So to address the first part of your question, Judge Graber, I think the key evidence in this case is the declarations that we submitted below in connection with our opposition to the TRO motion that set forth the violence, the threats of violence that have occurred at this facility, and the unsustainable and unsafe diversion of the government's limited protective resources that has been necessary to contain the violence there. I think you have to keep in mind.
So it sounds like you're relying on the local evidence. Am I right about that? The evidence having to do with Portland itself or Oregon itself?
Certainly, we are relying on all of the evidence, but the historical evidence from earlier this summer in Portland, for example, when the ICE facility had to be shut down for more than 3 weeks because of the violence and threats of violence, certainly informs what is the risk that the facility faces in Portland.
By the way, I do want to mention that, of course, the Ninth Circuit has a well-earned reputation of being a very liberal circuit. It's much less liberal than it used to be. Trump appointed a bunch of judges to the Ninth Circuit Court of Appeals. It still leans left, but it's not nearly as hard left as it used to be. Just FYI.
To remove all of the protective forces that we've had to divert to contain that situation. So I think that is one of the key errors here that the district court judge made, is taking this blinkered view of the statute, where we're only looking at what's happening in Portland in the days or weeks ahead of the federalization. And to your question about why is what's going on in the rest of the country relevant, that's because the government only has limited protective services at its disposal. They've had to call in 100 plus 115 federal protective services officers have been brought in from other locations and deployed to provide 24/7 protection of the Portland facility.
If you live in an Oklahoma zip code and have 0 DUIs in the last 5 years.
So this is a good argument. This is in addition to the one I just raised. The one I just raised was, well, if attacks by the same organization are happening elsewhere in the country, we can infer that level of violence is likely here in Oregon as well. He's making a separate argument. He's saying we're bringing up those attacks in other parts of the country because attacks are occurring in other parts of the country, and this crisis in Oregon is sucking up such a disproportionate share of our security forces available without the National Guard, that's what's impelling us to raise the National Guard. So the National Guard can come in and we can reallocate those ICE officers back to their normal offices.
And our declarations below explain why that is neither safe nor sustainable, that they're not equipped to deal with that.
How often is
Well,
that
speaking
done?
of sustainable, those folks have gone home. Am I right?
No. Some of them have gone home. there are so many of them deployed there. And certainly the president can take into account the fact that they are being pulled away from their normal duty stations, they are being tied down and are not available to address the rising violence that's occurring in other cities focused on thwarting enforcement of the immigration laws. And
How often does that happen where forces are reallocated like this? Is that unusual or is that regular?
I don't have historical data on this, but I have to imagine that a diversion of this magnitude is quite irregular. If you look at the declaration from the deputy director of FPS, he says quite clearly that we're not equipped to deal with this kind of ongoing, sustained unrest. While the officers are expected to be able to respond to emergencies, they are not expected to work 12 hours a day, 7 days a week, which has become the norm. That declaration states that is neither safe nor sustainable. And that's, I think, something that the president can surely take into account in.
Hey, this is a different case. This is the Letitia James mortgage fraud case. Apparently, she just got indicted. Frosted Sleet tells us, a member of this channel. Thanks for the heads up, man. The local Democrat Department of Justice holdover prosecutor was going to dismiss this case against Letitia James. And apparently she told a colleague that she was just going to delay things. She wasn't going to tell Pam Bondi that she wasn't going to indict. She was just going to drag out the timeline until there was so little time left, like in the James Comey case, that everyone would have to scramble like crazy in the last couple of days before the statute of limitations ran out, and maybe they would screw things up that would get the charges dismissed. So that DOJ holdover was just going to run out the clock on Letitia James. And she mentioned it to a colleague, and the colleague ratted her out, appropriately so. So that prosecutor got fired, and they put a new prosecutor in. And of course, now Letitia James has been indicted. So that's great news. She's just an unbelievably horrific dirtbag, as so many of these progressive fascist government officials are.
Analyzing whether the regular forces are able to execute the laws. Judge Graber, to go back to your reference to the situation in Los Angeles, I think there are two main differences between what's happening in Portland and what's happening in Los Angeles, and neither is material to whether the president had a colorable basis, in fact, in law to invoke the statute here. Of course, one main difference is the violence was on a significantly larger scale in Los Angeles, but of course, that was addressed here by the calibrated nature of the calling up of the Guard.
So many fewer National Guard were called up in Oregon than were called up in California. Folks, I got to let everyone know. I mean, I say this from time to time. It seems like almost every show. I see a lot of great comments in the chat that I'd like to address, like to pop up on the screen. But I have to reward the people who pay to support this channel with super chats and memberships. So if it's a super chat, I'll definitely pop it up and address it. And if someone's a member and they have a good comment and I happen to see it, I'll pop it up on the screen. But if it's neither a super chat or a comment by a member, I'm sorry. So, the link for membership is in the description. It's only 16 cents a day, folks. $5 a month.
200 members of the Oregon National Guard were called up compared to the 4,000 that were called up.
How many guardsmen were actually deployed? I know that it said 3,000 or 4,000 could be called up, but how many were actually deployed in Los Angeles?
I don't know the number. I think it was in the thousands that were actually deployed. It's significantly down now. My understanding is down in the low hundreds at this point. But the second difference that I wanted to focus on in Los Angeles is the president there made the decision to activate the Guard immediately to deal with the acute threat. Whereas here, we first tried to manage the situation with the regular forces, and the president only activated the National Guard after it became clear that that was neither safe nor sustainable. And the way the district court judge looked at this, where she refused to consider any of the evidence from June or July or earlier in the summer and didn't dispute that the conditions may have been met to activate the Guard then, effectively penalizes the president for using the National Guard as a last resort rather than as a first resort, and I think creates a bad incentive to do precisely that.
I have one, what I think might be my final question to you, which is really for for you and not for other counsel, and that is with respect to the things that the district court did consider. Are there any factual findings that you contend are clearly erroneous? And if so, precisely which ones?
I think the answer to that, Judge Graber, is no, because I don't think there is a dispute about any of the relevant facts. I think the question is whether the undisputed facts, particularly the undisputed facts in the government's declarations, suffice to establish a colorable basis for.
Discover the 10-second honey trick to stop memory loss. The secret the billion-dollar industry doesn't want you to know. If you suffer
invoking section 12406.
So let me just be sure I understand your answer. You are not contending that any of the district court's factual findings are clearly erroneous. You're contending that she should have considered additional facts or come to a different conclusion, but you're not contending that any of the findings she made are clearly erroneous. Is that a fair summary?
At least not insofar as her stating that X event occurred on Y date. We're not disputing any of that. If we're getting beyond whether certain facts occurred to what's, sort of the risk that's presented by that and whether that risk suffices to invoke the statute, I think there we're not in the circumstance where we have a factual finding. That's application of law to facts.
So is the assessment of risk as distinct from the effect?
So this is really a dishonest question by this Clinton judge. It's dishonest because there's lots of factual allegations that are made, and they're all subject to varying interpretations from different perspectives. And she's asking this lawyer for the Department of Justice to say, I want you, if there's any fact or way to view a fact that you would dispute, I want you to dispute it right now. Well, it's vastly too open-ended a question. Maybe there's a fact he doesn't disagree with, but he would disagree with the inference made from that fact. So, small changes in fact can result in big changes in legal outcome, but you don't know until you see exactly how that fact is going to be spun. You can't ask a lawyer, just tell us now, in this whole universe of facts in this case, all the amici briefs, all the motions that have been filed, I want you to tell me now if there's any one of those that you disagree with, that you dispute. You just can't do that.
Effect of the amount of risk, is that a factual finding? In other words, an assessment of risk as distinct from the effect of the amount of risk, is that a factual finding?
See, that's exactly my point. So what are facts? Facts are something happened on a particular day. This number of National Guard were called up. This number of ICE agents have been allocated from. Those are all facts that probably aren't disputed. It's in the record how many National Guard were called up. But then she switches to a factual finding by the judge. A factual finding is a conclusion the judge comes from, the underlying judge here, Immelgut, based on her interpretation of the underlying facts. Those are two different things. The facts may be demonstrable, incontrovertible, undisputed, but the interpretation and conclusion you come to from those facts is very much disputed here.
In other words, if someone, this is just a hypothetical, if someone says the person was driving at 8 miles an hour and that does not present a serious risk of running over a pedestrian.
See, you see the dishonesty there, right? The 8 miles an hour may be indisputable. It may be in the car's computer. It may have been tracked by a radar gun. Who knows? But whether or not any particular speed is enough to cause some kind of injury or damage, that's not a demonstrable fact. That's a conclusion someone's arriving at based on their interpretation of the fact.
Is the assessment of risk that stems from the underlying fact a factual conclusion or a legal conclusion?
I think in certain circumstances, an assessment of risk could be a factual conclusion. I don't think we have that here. I think what the district...
Again, a fact is different than a factual conclusion. So facts may be demonstrable, incontestable, incontrovertible, undisputed, but the interpretation of those facts... Now, legally, it's a legal term of art. We expect judges like Immelgut in this position to make factual findings, to come to factual conclusions, to interpret the facts in particular ways, to come to a decision. That's in dispute here.
Court said is that future risk is simply irrelevant, that you only come up to what's actually happening. I think that clearly has to be wrong because future risk dictates what regular forces have to do now to counteract that future risk. And that is why we've had to have so many protective services officers.
And by the way, the statute says, for example, the second provision of the statute says the president can call out the National Guard to stop a rebellion or a danger of a rebellion. Well, danger of a rebellion means it's not happening yet. You're inferring, you're speculating. I'll say inferring that a rebellion could occur. Speculation is when you're just coming to that conclusion in the absence of evidence. Inference is when you have evidence, you're looking at things happening, you're saying, you know what? I foresee a risk of a danger of rebellion here. That's enough to call out the National Guard. And of course, it's not certain. Of course, it may not ultimately happen. You're addressing a future risk.
Officers at this facility 24/7 in a way that's neither safe nor sustainable.
Can I ask about you've made a review, and by the way, I know you've asked for time. We'll give you enough time to answer all of our questions. It may take each of you over the allocated times.
And by the way, this Clinton judge on the left, she didn't let this Department of Justice lawyer get 2 minutes into his argument before she interrupted him with all these inane questions.
To ask about the reviewability, because you've made an argument that this is just not reviewable by the courts. And I understand your argument to be based on Martin, which has some pretty strong language that this is expressly within the discretion of the president.
So he's referring to a U.S. Supreme Court decision, Martin v. Mott, that held that when the president is making decisions about military forces, it's not justiciable. The federal courts have nothing to say about it. They have to defer to the discretion of the president. The check and balance on the president in that context is Congress can write a statute prohibiting the president from doing that, or Congress can impeach the president, but the check is a political check from another political branch of government, or the American body politic cannot reelect that president. It is not a judicial check from the Article 3, a political branch of government.
Newsom didn't adopt that argument. To what degree are we bound by Newsom that this is reviewable?
So I have not found any circuit.
So he just said Newsom. Newsom was the previous Ninth Court of Appeals case that dealt with the Trump calling out the California National Guard in LA. And that Court of Appeals case did not refer to Martin v. Mott, the Supreme Court decision. But if there's a contest between two court decisions, and one of them's from the Supreme Court and one of them's from the Court of Appeals, which one wins? Well, they call it the Supreme Court for a reason, folks.
A precedent that speaks squarely to that question. In the East Bay case, the court said that a published panel stay decision may be binding on future panels as to the same issue. I think I can take that off the table. We have preserved that argument. We do think it's correct. I will certainly be taking a run at the Newsom merits panel in a couple of weeks to try to persuade them that that's the one part of their opinion I think they got wrong. But for purposes of resolving this motion today, I think you can take that as the law of the circuit and ask whether we meet the very deferential standard of review that the Newsom state panel applied.
Can I just ask one follow-up question on that, though? Because this is something that I would be interested in your view of the history of the statutes, because in 1792, there was some review. It didn't look like it was judicial review, but there had to be a pre-clearance by a justice of the Supreme Court. Then in 1795, that provision was taken out. In 1831, the statute expressly gave total discretion to the President of the United States. And then in our current statute, 1903, that total discretionary language was taken out. Maybe you'll make that argument in the Newsom case, but I didn't see Newsom walk through that statutory history. And it strikes me that suggests that there might be some reviewability here based on the change between the 1831 statute and the 1903 statute.
So the reason I don't think that's right, Judge Nelson, is because I think.
So he's making a good point, Judge Nelson, here. He's saying because normally when you have like over time, different versions of a statutory authority and provisions are added or removed, it's presumed there's a reason it was added or removed, that the change was deliberate.
I think you should compare.
To me, that suggests that there might be some reviewability here based on the change between the 1831 statute and the 1903 statute.
So the reason I don't think that's right, Judge Nelson, is because I think you should compare the language of the statute as it exists today to the language of the statute in Martin and subsequently in Luther versus Borden. And it's the exact same language. The statute is structured the exact same way. It's whenever, in a set of conditions, the president may activate the National Guard. And the court in Martin said that that statute vested in the president's sole and exclusive judgment whether the statutory preconditions were met. And to the extent Martin left any uncertainty about whether that was binding just on subordinate military officials or instead also on the courts, I think that was cleared up in Luther versus Borden, where the court quite clearly applying Martin said that that was conclusive even on the courts.
So, and just one, maybe you've already answered this, but so Martin was binding in 1831. So would that language that was expressly put in the 1831 statute, in your view, would have been superfluous, and removing superfluous language in 1903, in your view, just had no effect?
I think that's right. I mean, we don't know why that language may have been removed. They may have removed it because they thought it was unnecessary in light of the existing precedent from Martin and Luther, and Congress enacted that statute in 1903 against the backdrop of those precedents. And ordinarily, we presume that when Congress takes language that has received a construction from the United States Supreme Court and replicates it in a new statute, it imports that settled construction of the statute. And for that reason, I think both as a matter of vertical stare decisis, a lower court is bound by Martin and Luther, and that is the correct interpretation of the statute because of that principle of interpretation. But again, I don't think this panel needs to get into that here. I think the likelihood of success on the merits in this case comes down to two questions that I'd just like to crystallize for the court. One of them about the law, one of them about the facts. The legal question is whether Section 12406 colorably authorizes the president to call up the National Guard when violence and threats of violence directed at federal officials and facilities has significantly impeded federal law enforcement and required an unsustainable diversion of the regular forces in order to contain it. That's the legal question. The factual question is whether the facts of record here create a colorable basis to believe that that is the situation in Portland. And I think the answer to both of those questions is quite clearly yes.
A colorable basis to come to that conclusion based on those facts that the conditions of 12406 have been met, unable to enforce the law with the regular forces or danger of rebellion in the context of tremendous deference to the president. So it's not enough. It's not like the judge and the president are on an equal footing here. And if the judge is 51% convinced the president made the wrong call, they can stop the president. It's supposed to be the president is like 95% wrong. That's the deference that needs to be overcome.
I'd like to ask you a couple of questions. One is to go to the factual.
So this is also a Trump-appointed judge. The judge in the middle, Nelson, and the judge on the right, Beatty, are both Trump class of 2018. The judge on the far left is Clinton class of 1997. She's 60. No, she's, how old is she? She's more than 60. I had written it down. She is 76 years old. Pushing 80. Pushing 80. Could be 77 years old. I don't know when her birthday is.
Issues. I'll ask you a couple of questions. One is to go to the factual issues. There's a statement in Deputy Director Cantu's declaration that there are 776 Federal Protective Service officers, and only 497 are inspectors. But it wasn't clear to me what that means. Does that mean that only 497 officers are available nationwide to protect federal property? Is there a distinction between the 776 and the 497?
I had understood, and I would have to go back and look specifically at the language, but my recollection and the way I'd understood that was those are the officers who have the requisite training to be able to deal with these sort of civil unrest and violent protests, and the others do not.
All right. So when he says 115 Federal Protective Service officers were deployed, you're saying that that means out of the 497 available to protect the federal building, which means roughly 25% of the officers available nationwide were deployed to court.
That's how I.
All right. So an interesting point came up that I want to address here. I'm saying these are Trump judges, the male in the middle and the woman on the right are Trump judges. And someone in the comments said, yes, but Andrew, it's like you talked about the other day. They still have to get past the state senators. And so the state senator, if it's a liberal state like Washington, Oregon, then it doesn't really matter if they're a Trump appointed judge, because the local state senators have a veto power over the judge. So you end up, even if you're Trump, even if you're Ronald Reagan, you end up in Oregon, for example. If you're appointing someone who lives in Oregon, they have to get not vetoed by the liberal Oregon senators, two of the most liberal senators in the government. So you end up, the only nominees who would be acceptable to those liberal senators is going to be a liberal. But we're not at the trial court level here. We're in the Ninth Circuit, and the Ninth Circuit is not all liberal. The Ninth Circuit looks like this. So, for example, I don't know where this judge on the right, Beatty, was appointed by Trump, but it could have been Montana. It could have been Idaho. And, of course, this would have been in, what did I say, 2018. So maybe before these places got so infected with Californians. So it's quite possible these two judges on the right, Trump appointees, are conservative because they, Nevada, Arizona, Alaska, all in the Ninth Circuit. And I got distracted, so I got to rewind it just a little bit.
Understood it, Judge.
There was, all right. So when he says 115 Federal Protective Service officers were deployed, you're saying that that means out of the 497 available to protect the federal building, which means roughly 25% of the officers available nationwide were deployed to court.
That's how I understood it, Judge Beatty. And I think that's why he also said that this is just not sustainable.
So the other question I have is more about our procedural posture. You saw the order on the administrative stay, and there is a second TRO that the district court entered after the first and after your notice of appeal was filed. And you are here before us now asking.
By the way, that was bizarre too. So remember, the sequence was Oregon and Portland sue in federal court. They get a TRO on Saturday. The White House appeals the TRO to the Ninth Circuit Court of Appeals. That's what we're here about now. And then on Sunday, the next day, the trial judge issues a second TRO. Well, the way this works is once the trial judge issues an order and the order is appealed, the jurisdiction of the case shifts to the appellate court. It's no longer with the trial judge. You can't have two courts simultaneously having jurisdiction. You can't have two captains of the same ship. So technically, the moment this was appealed by Trump to the Court of Appeals, Judge Immelgut lost jurisdiction over the case. And yet the next day, she issued a second temporary restraining order anyway.
For a stay pending appeal.
And of course, a court order in the absence of jurisdiction is worth as much as if I had written the order. It's worthless.
But don't we have the same issue that even if we were to stay the first order, the second is still in place?
There is that same issue, and I do want to be clear that the administrative stay that was granted doesn't, from our perspective, take the time pressure off getting a full stay pending appeal, because what we need is a full stay pending appeal so that we can then immediately go to the district court and say, in light of that, the district court should dissolve that second TRO, because the second TRO rests on the exact same basis as the first TRO. So if this court grants a stay pending appeal concluding that interim relief here was not warranted because the government's likely to prevail on the merits, or because there's no irreparable harm, or because of the sliding scale, or whatever, then I would expect the district court to immediately dissolve that second TRO. And if the district court did not, then at that point, I'm confident that we would be back up here again.
Well, as things.
Would you have run the time? I mean, you haven't even filed a notice of appeal. What if we?
We're not going to run out of time to file a notice of appeal. That's 60 days. The TRO is in effect for 14. So
I have a follow-up question to that, though. We are to decide.
It does feel like an oversight. So with the first TRO from Immelgut, the White House filed this appeal within minutes, hours, the same day, with the Ninth Circuit Court of Appeals. That was Saturday. She issued her first temporary restraining order against Trump's calling the Oregon National Guard. The White House appealed it immediately on Saturday afternoon. Sunday night, she issued another TRO, the second TRO, saying he can't even call up the California and Texas National Guard either. He can't call up any National Guard. The White House should have appealed that to the Ninth Circuit too.
At Fisher Investments, we know a lot goes into that question, which is why we've made this quick and easy plan
separately, because then that would also be in front of this panel. Right now, the position of this 3-judge panel is we're only here to listen to argument about the first TRO because the second TRO was not appealed to us, so it's not before us. I would argue the second TRO is illegitimate because it was issued in the absence of jurisdiction having shifted to the appellate courts. And now what the DOJ lawyer is saying here is, well, the rationale was the same for both. So if you dissolve the first TRO, that should have the effect of dissolving the second TRO. And if the trial court judge doesn't do that, we're going to be right back here in front of you again. And that seems like, the middle judge here was like, why are we doing all that circus?
On the state of the world as it exists today. And as it exists today, one of the things that you have the burden to demonstrate here, I think, is harm, that there's harm. And if the federalized National Guard members cannot be deployed, which is the state of affairs today, what is the harm that you are suffering? I mean, even if we grant the stay right now, I guess I have trouble seeing how there is harm if nothing changes.
Well, the harm certainly is that we cannot deploy the Guard members to address the risks of violence.
That's right, but that's not because of this case at this point. It's because of the second TRO.
It's because of the terms of both of the TROs, which rest on precisely the same reasoning. And if the panel thinks that in order to establish irreparable harm, we need to bring that second TRO up for appeal now and get it consolidated, we can certainly do that. Our judgment had been that we didn't need to burden the court with that, because if the court grants a stay pending appeal here, that should be binding on that second TRO, and it should be dissolved by the district court. And so that would redress our irreparable harm.
So can I ask about the 14-day nature? That's also different than California. California didn't have the district court did not put the 14 days in there. Does that mean we need to rule before the expiration of that? I mean, do we know whether the district court is going to extend that? Can the district court extend it? If we don't rule within 14 days, does this all become moot? What's your view on all that?
So the district court has scheduled a hearing, I believe, on October 17th, which is the day before the TRO expires on October 18th, to decide whether or not to extend the TRO for an additional 14 days. If the TRO does expire either on the 18th or after it's extended for another 14 days, that would render this appeal moot. Hopefully, our view is that the panel should grant a stay pending appeal well in advance of any of that. And that would give guidance then to the district court. The court has also scheduled a preliminary injunction hearing for the end of the month on October 29th. And I think if the court granted a stay pending appeal here, the court's analysis of the likelihood of success on the merits and the balancing of the equities would inform the preliminary injunction analysis. and hopefully preclude the grant of a preliminary injunction, or if not, at least require the district court to stay any preliminary injunction that's granted. Otherwise, we're going to be right back up here repeating everything that we've just done.
Okay. Any other questions by my colleagues?
No.
Thank
So here's a good super chat. Art Dragon, who bought the blue version of this tie. I wore it this morning, Art Dragon. I don't know if you were with us. Art Dragon bought my blue Trump tie. This is my red Trump tie. Thank you very much, sir. It was a $100 super chat he contributed for that purpose. So very generous of him. He asks, how can a judge from one state prevent POTUS from calling out National Guard from another state where that judge has no jurisdiction? It's a good question. I mean, where's the standing? Where's the standing of the plaintiffs, the state of Oregon and the city of Portland here? I think what the judge is going to say is, well, I concluded that 12406 didn't justify calling up the National Guard. In that context, we were only arguing about the Oregon National Guard, but they're not different really in terms of when the statute's triggered from the California National Guard and the Texas National Guard. And that's probably her reasoning. Again, I don't, it's my view she doesn't have any jurisdiction or authority here because this decision is not justiciable.
you. We'll still give you 3 minutes for rebuttal.
Thank you.
May it please the court and counsel, Stacey Chaffin on behalf of the plaintiffs. The president's 12406 determinations are entitled to great deference, but that deference has a limit, and that limit is this case. Where the president's determinations are untethered from reality, they cannot represent a color.
All right, I mentioned at the start that the Department of Justice lawyer, he'll work in the Court of Appeals division of the Department of Justice. He's probably arguing before the Ninth Circuit Court of Appeals a couple times a month, maybe more. This woman working for the state of Oregon may argue before the Ninth Circuit Court of Appeals once a year, if that much. And you see it right here. You notice she's reading. The Department of Justice guy was just verbally he was just speaking, making his argument. She's reading off her laptop or a piece of paper or whatever she's using.
Tolerable assessment of the facts within a range of honest judgment. I'd like to take first, Judge Graber, your question about what document represents the president's determination. And the answer is that we don't know. It's very unclear what document the president relied on to authorize the federalization of the National Guard. The
statute doesn't require any document. So this is like, normally you lead with your strongest argument, folks. This is like the weakest argument, or maybe it is her strongest argument. But it's not very good.
Documents that we do have are the June 7th memorandum, which was issued in response to the escalating ICE protests in Los Angeles. That memo is specifically referenced in the September 28th memorandum from Secretary Hegseth that mobilized the Oregon National Guard. That memo that was issued not only relies on the June 7th memo, it references it, and then it also attaches the June 7th memo. But that memo was issued 4 months prior.
But you're not suggesting, I mean, you have raised an APA claim, but you're not suggesting that we need some formal order, that represents final agency action by the president, are you?
Not at this time. And we're not making arguments regarding the form of the order itself. But if the president was relying on the June 7th memorandum, that was both not relating to Portland, and it's exceptionally stale by the time that the troops or the National Guard was actually federalized in September. There's a significant deficit of time.
So under your theory, then we can't consider any of the facts because the president didn't mention them? I mean, I don't know what the impetus for your argument is on that.
Well, if the president, the June 7th memorandum, if that is the basis for the federalization of the national troops, it has nothing to do with Portland. And it only had to do with the circumstances that were happening at that time in June.
Counsel suggested, though, that the social media post that said there's war in Portland and go forth and fix it is sort of an addendum, if you will, or a direction to apply the June 7th memo to Portland. What's your response to that?
Certainly, the statute doesn't identify for us the form that the president's determination needs to take. And if the defendants are relying on a social media post, that social media post still isn't, it doesn't represent a colorable assessment of the facts within the range of honest judgment.
She's just quoting the Ninth Circuit Court of Appeals from the Newsom decision about the call out of the National Guard verbatim there. The statute doesn't require any particular form of documentation or any documentation. So the president doesn't have to produce any. And if he does produce any, it can be in any form he likes. You don't do it the reverse way. You don't say the statute doesn't call for any documentation, but we don't like how the president did it. That doesn't make any sense.
Within that document, the president references Portland as war ravaged, which we all know is not accurate. And then it also calls Portland under siege, also an inaccurate statement. Because these are inaccurate statements, they can't form the basis of a colorable argument under 12406.
Well, that may be true, counsel, but you're not denying. I mean, what we heard.
By the way, I see the Department of Justice guy like stepped back from his lectern and took a seat. I would not do that. I think that's just bad theater. Stay at your lectern. The woman for the state didn't step away from her desk when you were arguing. She was right there in camera, right there in frame. Get back up at the lectern, dude. What do you got, hemorrhoids?
From your opposing counsel is there's really not a lot of dispute on the facts. There might be dispute as to which facts are relevant. Do you think there's a dispute of facts as to what's happened in June, July, August, September? I mean, are there points in time where you think you have a disagreement on what's actually happened with opposing counsel?
I think we disagree with the framing, but I would direct this court to the district court's findings regarding those facts. The district court found that the Portland ICE facility protests were small, less than 30 people, largely sedate and generally peaceful.
Okay, hold on. That's clearly erroneous because there's clearly been protests that were above 30. I mean, unless you're trying to limit it to certain time periods. We have evidence in the record that there were protests as much as 200.
It was generally small. And
I think there were 3 instances where it was large over that time period. But when we're talking about how to, as you say, frame the facts, can you go on to answer my other question, which?
Yeah, that was nice. That middle, the guy judge in the middle, Trump appointee, 2018, took her claim of fact and said, well, that's clearly erroneous. In other words, WTF, woman.
Is what is a rebellion? And, what is the standard that we should be?
Oh, my God. So dishonest by this Clinton judge. Now she knows that this woman lawyer was going to get beaten bloody on her misrepresentation of the facts. So she's changing the topic. Let's not talk about that. Let's talk about what the definition of rebellion is.
Applying.
A rebellion is an open, organized, or armed resistance to an established government or an attempt to change the government or the leader, usually through violence. That is the appropriate definition that this court should adopt in this case.
And where does that come from?
The older definitions in Webster's. And I would highlight for the court that the first time that rebellion was added was in 1861, and that was shortly after the Confederacy declared independence and the first shots were fired at Fort Sumter. And it's with that context in mind that we should interpret the word rebellion. And it certainly isn't.
That's an idiotic take. Didn't she just say that that language is added to the statute before the Civil War and before the shots were fired at Fort Sumter? How could the legislature have incorporated a meaning of rebellion that took into consideration facts, events in the future? That's insane. I got to rewind it just to hear if she's actually said that.
Okay, whiskey.
Highlight for the same the older definitions in Webster's. And I would highlight for the court that the first time that rebellion was added was in 1861, and that was shortly after the Confederacy declared independence.
Oh, after.
And the first shots were fired at Fort Sumter. And it's with that context in mind that we should interpret the word rebellion. And it certainly isn't.
What about the Whiskey Rebellion?
The Whiskey Rebellion certainly comes into play as well, but I think
Could that inform our definition of rebellion, or was that the president acted under some different provision?
I'm sorry, I don't know the exact answer to that question, but I can say that the defendant's proposed definition here is so broad that it could potentially encompass a significant amount of protected speech and protest activity. In their briefing,
my concern is and that may
pure speech or protest activity constitute rebellion.
To be true.
Even if that were a risk, it's not happening here. We have violence, we have arson, we have explosive devices, we have machetes and knives and guns.
But your definition, and perhaps the definition applied by the district court, seems so narrow that it doesn't even comport with the vast exercise. I shouldn't say vast, it hasn't been that many, but with those incidences where the National Guard has been used or the militia has been used, it wouldn't satisfy the rebellion.
Remember, the National Guard was called up over this. Over this. We don't have to go all the way back to the Whiskey Rebellion. This is 1960s. Eisenhower called out the National Guard to Little Rock, Arkansas, because they were protesting against integration of the schools, racial integration of the schools. Were these people trying to overthrow the entirety of the federal government? Of course not. They were upset over one particular issue. Nevertheless, the calling out of the National Guard was legit.
And prong in those either.
and I can't specifically point to the situations where the rebellion prong has been utilized, but I do know that in Newsom, this court identified that both invasions and rebellions are unusual and extreme emergencies that threaten the normal operation of civil government. So it needs to be this significant, intense, large-scale situation that really it has such a large impact on the fabric of the country. I mean, if we're comparing...
Again, the National Guard was called out for Little Rock. Little Rock, Arkansas. It wasn't the whole nation. The Whiskey Rebellion was in one region of the country. It wasn't the entire nation. This is nonsense.
To an invasion from a foreign power, that's something that goes to the heart of the safety of our country. And when it explains also why the president has deference in these circumstances, that he's expected to respond to sudden emergencies that are upon great occasions and under circumstances which may be vital to the existence of the Union. It is under that framework that we define the phrase rebellion or even threat of rebellion. And
Oh, I'm sorry. I was going to ask you to move to my question concerning what type of evidence is relevant, particularly in terms of time. How current the proclamation or memo of June 7th refers to current circumstances that would justify mobilization. So what, in your view, is the appropriate time frame to be looking at for determining whether the statutory standard is met?
From a kind of larger perspective, that really is going to depend on the circumstances. And we're not asking this court to create a very specifically defined set of factors that need to be evaluated in every case. But in this case, when the president has authorized the federalization of the National Guard in Oregon, we're asking this court to look at the circumstances around when that happened.
So do we look from June 7th forward, or do we look only at September or something else?
Annuities are complicated investments that can cause complex problems. Annuity Insights from Fisher Investments can help you examine everything from the layers of fees to inflation's impact on your income. Download your free guide today.
If you wake up with brain fog that makes simple decisions feel impossible, or your thyroid feels sluggish no matter what supplements you take, or you can't shed that stubborn weight clinging to your midsection, maybe you've noticed thinning hair that won't grow back, premature wrinkles.
It would make sense it's reasonable to look at around the time period when the
By the way, why should a judge get to make this decision as opposed to the commander in chief? Why does a judge say you can only look at the most recent couple of days or the most recent couple of weeks or the most recent couple of months or the most recent couple of years? Why is this within a judge's discretion? The apolitical, unelected, black-robed, tyrannical, inferior district trial court judges, not accountable to the political will of the American people, lifetime appointment. Why do they get to make these calls as opposed to the elected Article II executive branch commander-in-chief of our federal forces?
the National Guard was actually federalized. What happened in June, and we acknowledge
Isn't
that
June around the time period of when the National Guard was federalized?
it was 4 months prior, and that is significant because there can be, and there was, a very large delta between what was going on in June and what was actually going on when the president.
So could the president have, in your view, nationalized the Guard in June?
I think we'd be having a different conversation, and it would certainly be a closer call.
And
But
so the president loses his right to do that, in your view, because he waits to see how things turn out on the ground.
I think in the moment, the president can make the decision to manage the situation with the normal forces. And here, what we have is even that situation in June. I'd point the court to, I think it was June 14th is probably the worst of the circumstances.
Yes. I think I could make this argument better for the city of Portland and the state of Oregon than this female lawyer is doing. If all you have to do is avoid her stupid arguments, and it would be better. What's her strongest argument? I still haven't heard it. And we're what? We're probably halfway into her case here.
That happened, and that day, the threat of violence from the protesters lasted 2 hours. And it's with the use of normal forces that they could stop the kind of incursion of the protesters, push them back, and everyone kind of had the safety that was necessary with using the normal forces. That stands in stark contrast to what happened in California. In California, there was a span of 2 days where they had consistent and increasing protest activity, where they were penning down officers, throwing concrete chunks. They used dumpsters as battering rams to breach the facility. And the next day, the confrontation lasted for another 7 hours. Protesters boxed in officers, threw Molotov cocktails, mortar-style fireworks, rocks. They blocked traffic and burned a vehicle.
But that's a little bit of the irony here, is that because the president acted in June in LA, I mean, I don't know that we have I don't know, but it seems like we don't have the same level of violence going on in LA right now. But the president acted when there was violence, and you're saying, well, if you don't.
That suggests that it worked, doesn't it? That suggests there was violence and disorder. The president was unable to carry out the laws with the available regular forces. He called out the National Guard in California, and he pacified it. And now it's quiet. Isn't that an argument for calling out the National Guard in Oregon?
Hit it within a narrow window, you lose your right. That just seems unnaturally constrained. I mean, what the president did was bring in 115 FPS officials, and that has quelled the violence to some degree, it seems, but it hasn't abated it. I mean, there's still violence going on, right?
Well, what we have is a finding from the district court that the federal law enforcement officers, unaided by military forces, were capable of not only quelling the violence in June, but also preventing it through September. These are.
I'd like to ask you about some specific facts that I don't think are disputed. So
this is another Trump appointee, also class of 2018, on the right here. Oh, as long as I paused it. Why no mention of the Bonus Army March? breakup in 1932 by Hoover and MacArthur. No U in MacArthur. And I think it's an E, MacArthur. Yeah, many people don't know this. So if you don't know, after in World War I, our soldiers were promised a bonus. And the bonus was to be paid at some date in the future. But then, of course, we had the Great Depression. People were in desperate straits. So a lot of the World War I servicemen marched on Washington, D.C. to demand that their bonus be paid early so they could have the money to feed their families. And President Hoover sent in the U.S. military, including, I don't know his rank at the time, but he was a cavalry officer, MacArthur, later the famous General MacArthur, and broke up the march with violence. I don't know why that's not more commonly known as American history, but it's one of those things that we really don't teach.
The facility was forced to close. It was inoperable for almost a month, from June 13th to July 7th. And the declarations from the...
And there wasn't much violence happening when the facility was closed. So isn't that unable to execute the laws with the regular forces when you have to close the whole facility for a month?
The director of the Federal Protective Services and the field operations director from DHS state that the facility only reopened because of a surge of 115 Federal Protective Services officers to Portland, right? So
discover the 10-second honey trick to stop memory loss. The secret the billion-dollar industry doesn't want you to know. If you suffer from memory lapses, confusion, or brain fog, pay attention. You need to see this. This can change your life, just like it changed mine. I'm a woman who managed...
Those are facts that occurred, but that the district judge didn't consider because she apparently viewed them as out of time, that this had occurred. Are those not facts that are relevant for the president to determine the threat and whether there's a threat to DHS being able to enforce the 400 laws it's tasked with enforcing? I mean, they couldn't operate a facility. I don't know that ever happened in LA. There were attempts to breach a facility. Here, a facility was actually closed for almost a month. And the record includes more than one, at least 2 attempts to burn the building down and vandalizing the building so that it's difficult for the officers to move in and out of the building and increases danger. And the building is now currently boarded up, and the city has told DHS they have to remove the boards. So that means the facility presumably will be inoperable again.
Did you know that? Did you know that? So they had to put plywood over the windows and the doors to prevent a breach of the building by these rebels out in the streets. And then the city of Portland issued them a zoning violation for having the plywood up and ordered them to take the plywood, securing the building to take the plywood down.
So why is all of that irrelevant to the president's decision to federalize the National Guard?
Well, I'd like to push back a little bit on the reframing here. What we have is in early June, the facility was closed for 2 weeks. During
specific dates, June 13th through July 7th. That is not 2 weeks. It's about 3.5. And I think it's properly characterized as nearly a month.
This lawyer decided it was a good plan here to suggest that the judge deciding her argument is misrepresenting the facts. Does that sound like a good plan to anybody? Good Lord. Has she never argued before a judge before? That's why we're getting this snappy response from the judge.
But the facility was
in early June. The facility was closed for 2 weeks. During
specific dates, June 13th through July 7th. That is not 2 weeks. It's about 3.5. And I think it's properly characterized as nearly a month. But the facility was indeed closed, but the district judge didn't consider it because it was in June. So if I understand your position, only things that happen like September 24th, 25th, 26th, I mean, a very small window of time, those are the only days that the president could have legally considered when deciding whether there was a threat to the enforcement of law?
Well, if we're talking about the third prong, the inability to execute laws with the regular forces, that is a current temporal requirement.
Okay, so what is your basis for saying that? Because I didn't see the Newsom, but what is it, where is it that it says there's a they talked about the facts there, which happened to include events that had occurred in the preceding days. Here, the president relied on, according to the declarations that have been presented, on the facts leading up to the order from June, July, and August and September. So there's a period of a few months where things were unfolding on the ground. And what I think you're saying is we can't consider any of that it should only be a few days. But what is your basis for saying that?
The text of the statute is the basis. So if we look at the third prong, it says the president is unable. That is a current inability to execute with the regular forces the laws of the United States.
And is that a day by day? So that, I mean, if we said forces are.
By this reasoning, rebels, people in rebellion against the federal government could prevent the president from activating the National Guard if they only engage in violent rebellion every other day. If they did it every other day for 10 years, the president would not have the authority to call out the National Guard to put down the rebellion. Because by the time he got around to it, the next day it would be quiet again. And they'd go to court. They'd say, well, it's not happening right now.
Allowed. And then what? We come back the next day and say, oh, well, you got it under control. Now they're not allowed. Then it goes back up. Oh, they're allowed. I mean, it just seems like such a tortured reading of the statute. I mean, I'm not even sure President Lincoln would have been able to bring in forces when he did, because he'd have to wait. You know, if he didn't do it immediately after Fort Sumter, your argument would be, oh, things are okay right now. It just seems.
What is the effect of the June 7th authorizations statement that the National Guard should be performing federal functions at locations where protests against these functions are occurring or likely to occur based on current threat assessments?
My mind got so sharp that even my husband asked what the hell I'd done. All I used was that fridge trick with honey.
So does that limit how we or how Secretary Hegseth would have had to consider what was currently appropriate?
Yes, if the June 7th memorandum is part of this court's evaluation of the president's determination, it is limited by the current situations. And I would also, again, just direct this court back to the text of the statute, which there is an expectation that the circumstances are going to be evaluated as they happen. And that makes sense because these are emergencies. These are unusual circumstances that would immediately require the president's attention and response. If these are
Just think about it. Just think about it from a historical perspective, okay? So maybe in 2025, you could argue Trump could activate the National Guard at 9 a.m. in the morning, and by 3 p.m. in the afternoon, they would have been deployed from anywhere in the country. Just put them on a jet, parachute them in, airborne National Guard. The same day they could be dropped in. But, of course, that wasn't true for most of America's history. Lincoln called out the Guard. What do you think the time interval was between him calling out the Guard, a National Guard, and it arriving at the place of conflict? Days? Weeks? They marched by foot. George Washington, he didn't even have trains. So George Washington goes to fight the Whiskey Rebellion. When they make the decision that they're going to intervene, they're going to activate the National Guard, how much time passes between that and when he actually arrives at the scene of conflict with his troops? It's not the same day. So in that intervening period, if the rebellious forces just take a day off, suddenly that neutralizes the ability of the commander-in-chief to have activated the National Guard. That doesn't make any sense. That can't possibly be what the 1798 original statute meant, or what Mott v. Moss, the U.S. Supreme Court decision in the early 1800s meant, or what was meant during Lincoln's era.
Circumstances that are so significant that they could challenge kind of the fabric of our nation, the threat of invasion, they need an immediate response. And there isn't an attempt to penalize the president for waiting. there is a requirement that the circumstances as they happen be so significant that we need to federalize the National Guard. And
Well,
there's
actually, for number 3, I don't think that's true. For 3, it says the president with regular forces can't execute the laws. I mean, I'm sort of trying to figure out how a district court of any nature is supposed to get in and question whether the president's assessment of executing the laws is right or wrong.
Yep, exactly. That is the heart of the problem here. The district trial court judge has neither the responsibility, nor the competence, nor the expertise, nor the experience to make this call. They're not the commander-in-chief. They are an unelected black-robed, tyrannical, inferior district trial court judge. And I just thought this was a funny comment. Can you imagine going to a bar after a hard day's work, sitting down at the bar, when all of a sudden this Southeast New Hampshire online law school grad explains her current case to you? I think it's actually Southern New Hampshire. I don't think it's Southeast New Hampshire. Southern New Hampshire. And do they have a law school? It is an online institution, so online law school, interesting.
Well, this court has already concluded that there is judicial review. Of that
I understand that, but it's also great deference. And I mean, here, it has to be colorable. And so when the president comes in and says, look, we've got 115 FPS forces that aren't normally in Portland, and we've had to move them, this is straining our ability to execute the laws. I don't understand how you can question the behind the scenes to say, oh, no, that.
Right. And it doesn't have to be unable to execute the laws in Portland, Oregon. It can be he's unable to execute the laws elsewhere in the country because he's had to reallocate all these ICE officers from their normal duty stations to Portland, Oregon. So they're not where they would normally be.
Can't be right. I mean, we don't have a view into what laws are trying to be executed or how they're being impinged. But why isn't that colorable?
Because it's not true. Unfortunately,
It's not true that 115 FPS forces have been there since it reopened in July?
Well, we do have in the record that a lot of the surge forces were returned before the president's announcement. So I understand that these declarations kind of, they discuss the worst of the circumstances, which I understand, but they're also written by supervisors who don't work in Portland. They're from outside of
I have absolutely no idea. The district court said the same thing. I have absolutely no idea what that has to do with anything.
Because
I mean,
we were direct.
You want to focus on what's going on outside, and it doesn't rise to this level. But that's not what the statute says. The statute says the president can't execute the laws. That's an internal decision making. And whether there's a ton of protests or low protests,
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device. Here's what changed in just 2 weeks. In the first 5 minutes, gentle heat therapy increased circulation, delivering oxygen and nutrients to tired, strained nerves. Vibration massage kicked in to melt away tension built up from standing, walking, and years of discomfort. And after just 15 minutes, compression
they can still have an impact on his ability to execute the laws.
But this court has said that minimal interference isn't enough to raise to the level of an inability to execute laws. And that's what we have here. We have, yes, in June, there were more intense protests, but we have the district court identifying that the normal forces were able to manage those protests, which is within the job responsibilities of FPS generally. This is what we do. They do. You have from the declaration.
But that just seems to be the wrong analysis. And the district court did this. The district court said, well, look, people who acted violently were arrested, so everything's good. But that's not what the statute says. The statute.
I don't think this judge is voting with the city of Portland in the state of Oregon. And I don't think the judge on the right, look at her face. She already had to correct this lawyer for suggesting that the judge was misrepresenting the facts. That's 2 out of 3 right there.
Says the president can't execute the laws. And I'm just trying to figure out why we're giving, district courts the ability to say, well, this is what I see on the outside.
What she's basically arguing is we should give the unelected black robe tyrannical inferior district trial court judge the great deference. That's not what the Ninth Circuit Court of Appeals said in Newsom. They said the president's supposed to get the great deference.
So therefore, I'm going to transfer that onto what's going on behind the scenes. And we have declarations that say that it is impeding their ability to perform their function.
We have declarations that say we're short-staffed. We're having administrative difficulties because we don't have enough people. That is not a reason to bring the military into the streets of Portland or any other city in the United States. There needs to be something more than a deficit of employees to raise to the level of such a significant.
This is just a bad argument. There's a statute. These are words written down on paper. 12406 Clause C says that the president's unable to execute the laws with the regular forces. If that's the case, it doesn't matter why he's unable to. He should have hired an extra 10,000 employees just in case we were going to have rioting in Portland. That's insane.
Incursion into the sovereignty of a state. It needs to be more. And this is the case.
Into the streets, the deployment is limited just to the protection of federal personnel and federal property. So I saw quite a bit of that language in the motions suggesting that National Guard members would be deployed to patrol the streets of Portland, which is, I don't think the government has ever said that is the intent. The idea is to protect the building so they can remain open for federal personnel. But
what we do have, though, is a history of a very expansive and almost strained reading from the government of the district court orders. And it would, because this authorization is to protect any.
A strained reading? I think she's referring to the fact that when Trump was got the restraining order, that he couldn't call out the Oregon National Guard. He instead called out the California and Texas National Guard. And the district trial court judge, because she had written herself a very narrow restraining order that Trump was able to just waltz around, the judge didn't say, my bad. If I meant every National Guard unit, I should have said that. The judge said, you're just disobeying the spirit of my first order. We write things down for a reason. Words have meaning. Specificity in the law matters.
Federal government.
By the way, that's particularly true in a restraining order. Restraining orders in particular have to be written down so that the party being restrained knows exactly what they're allowed and not allowed to do. And then they're restrained by the exact words in the order. You can't expect someone to get a restraining order that says, don't do A, and they go, okay, and they do C, and then the judge comes back and said, well, I meant C also. That's insane. If the judge in Oregon wanted no National Guard unit activated and deployed in Oregon, she could have written that, but she didn't.
Location, any federal personnel go throughout the city to execute whatever their mission is. And there's no, as of the drafting, there's no specific limitation that they're going to only be in.
But why would we enjoin it up front? I mean, I want to be clear. I'm very sensitive to the slippery slope argument that's being made here and the slippery slope argument that's being made in LA and around the country. This is something that, clearly the founders were concerned about.
We'll get right back to the show. But first, let me tell you about one snack that has been an absolute game changer in my.
There's been a lot of debate about how this should be used. So I'm not trying to diminish that. It may well be that the forces are used in an improper way, but we don't have any evidence of that right now. All we have is a document that says we have a federal facility under attack.
Yeah, if Trump ends up using these National Guard in a way that Oregon or Portland thinks is unlawful, they can come to federal court then and argue this specific thing he's doing is unlawful. But what they're arguing for is for an unelected black robe tyrannical inferior district trial court judge to be able to issue a restraining order against the president for what he might speculatively do.
Or that violence has been, forced it to close down, and we want to protect it. That doesn't strike me as a glaring overuse on its face. Now, if what happens is what you're suggesting, that they do engage in law enforcement activities, then obviously we have another problem. But that's not even what the district court found. I mean, you couldn't find it. There's no deployment at this point.
Well, certainly. I mean, we're not talking about like the violations of the Posse Comitatus Act at this point. It is a bit speculative. But what we have
what was
is
that? Did she
Posse
just
Comitatus
pause
Act
and look
at
up
this
at the
point. It is
ceiling?
a bit speculative.
She did. She paused and looked up at the ceiling. She's trying to figure out an answer.
But of the Posse Comitatus Act at this point, it is a bit
Look at her.
speculative. But what we have is from Newsom, we know that this court has a role in evaluating the president's determinations. There is a direction that is this court's role. This is the case, though, that represents the outer limits of the president's authorities. We have in the month leading up, not even the week, if we look at the entire month of September, the district court found there was one instance in the kind of the weeks leading up where protesters shined flashlights in the eyes of drivers. There was also,
I mean, if that's true, then I think we've got a problem, because I don't think that's what the record says. I mean, if the district court really said that's all that happened in September, then the district court's clearly erroneous.
Bam. This is dishonest by this female lawyer, because she's saying the district court only found this. But there are attestations in the record, sworn affidavits from tons of people, tons of ICE officers at this facility, FPS officers, listing all kinds of stuff that's going on. That doesn't disappear because the district trial court chose not to talk about it in her order. That's still evidence in the record. So she's trying to pretend that the evidence only exists if the district trial court chose to write about it in her order. That's nonsense. That's what this judge is finding so objectionable. Judge Nelson in the middle here.
I didn't think that
flashlights in the eyes of drivers. There was also,
I mean, if that's true, then I think we've got a problem, because I don't think that's what the record says. I mean, if the district court really said that's all that happened in September, then the district court's clearly erroneous. I didn't think the district court said that. I thought the district court actually detailed more than just one incident in September where flashlights were shined in the eyes.
well, Your Honor, that's the record, though. Even if we go back to
Well, we'll have.
That's the record. Sorry, Jason, I'll come right back to you. That's the record. She's saying just ignore the actual evidence in the record. Only look at what the trial judge decided to write about. And the judge is laughing at her. The judge is saying, no, I'm not going to do that. I'm not going to pretend evidence in the record doesn't exist because the judge didn't write about it and you wish it didn't exist. That's insane. Back to this. I retired. Jason says, thanks for the $5, man. I retired from a National Guard unit, and I can tell you to fully mobilize, it could take me up to a week. On a first day call up, you may get 25 to 50% of the unit. Right. So these Antifa and rebellion could learn from the news that Trump has decided to activate a National Guard unit and just say, all right, guys, let's take a couple days off. and then these liberal lawyers would come to federal court and say, well, you know, Trump could have called them out when stuff was happening, but stuff is quiet at the moment, so he lost the authority to do that. I mean, that's not just how the world works. Madness. And Eclectic Deb, $5 writes, the fact that the city ordered them to remove the boarding on ICE building windows proves that the city is actively working to thwart federal law. Yeah, that would be relevant if we had a lawsuit against the city. That they call it ICE application, at least. You don't get the
to go into it, but I thought the district court actually detailed more than just one incident in September where flashlights were shined in the eyes.
Well, Your Honor, that's the record, though. Even if we go back to
he laughs at her.
Well, we'll have to go into it, but I don't understand the record to be that for September. I understand it to have gone down, but not that there was one incident and that was it.
That's not us saying, there were certainly protests throughout the month of September, but they were, as I earlier mentioned, and the district court found, small, less than 30 people, largely sedate, generally peaceful. That's what was happening in September. So there was an incident on Labor Day on September 1st where there were increased protests. 125 people were involved in the activity. But what we have is the statement from FPS that they were not concerned with the group. That's at 46-1. This is the day when the guillotine was displayed. But
Right.
that's arguably protected political speech. There were 40 people who remained after the larger group left, and they did arrest a few. After that, you have September 2nd, completely uneventful. September 3rd, there was a drone flying. There was some altercations. Everything was managed. That's the consistency throughout the month of September. And there were occasions when there might be, a larger number of protesters, but they were generally calm and sedate. And any of the sporadic and kind of more minimal criminal activity was appropriately handled by law enforcement resources. And that's what's supposed to happen, because the situations that we're talking about, even the situations where it unfortunately could include an assault on a federal officer, that's a crime. That's a crime that was handled. They were arrested. And I understand that the U.S. Attorney's Office had 22, they're prosecuting 22 defendants. That's how this process is supposed to work. It's not that there is a protest, and then you just send in the military.
What a weird argument. So what she's arguing is that the federal government has to allow its officers to be assaulted because they can always prosecute the people who committed the assault. I'm pretty sure the government's position would be, no, we're allowed to have sufficient resources on hand. So we're not just sending our officers out to be beat up by these Antifa shitheads.
This is protected speech. And for the most part, it is calm and sedate. And
assault is not protected speech.
So the drone on, I guess this is the Wednesday, the suspect got violent and spit on agents. He was arrested and booked.
That's general criminal activity that's handled appropriately by law enforcement. On the 4th, you have 20 protesters, and then there's only 15 at 8:30. On the 5th, FPS said it was a small group with low energy, no calls for service. On the 6th, there was 50 to 60 active protesters, lots of noise. They were energized, no arrests. September 7th, 7 people, low energy. September 8th, 30 people. There were an altercation between protester and a counter protester, not against the facility. It continues, and I'm happy to go through the record.
No, this is helpful. We'll have to go through it. I mean, I don't think there's any question that it's gone down in September, but part of the problem there is it's gone down largely because of this influx of other forces, which is outside of the regular use of those FPS officials. So
does the record show us how many of the extra people remain in Portland?
You see how that old Clinton judge just interrupts the Trump judge, just talks right over him? Did you notice that? How effing rude. How rude. Because the Clinton judge sees that things are not going well for the Oregon lawyer. How effing rude. The guy's talking and she just talks right over him.
FPS.
Regular of other forces, which is outside of the regular use of those FPS officials. So
does the record show us how many of the extra people remain in Portland, the FPS, and how many have been sent back to?
I don't know if you heard the question. I think it was, does it show? I mean, we know that up to 115 came. Do we know how many were there of the extra FPS? Maybe this is for the
or something. Did you not hear?
Yeah, we're not hearing you very well. It's kind of getting muffled for some reason.
Well, I'm
There you go.
okay.
There you go.
I'm right by the microphone. Does the record show, the record is in front of us, how many of the FPS officers from outside of Portland who came in remain in Portland now, and how many have been sent back to somewhere else?
I haven't been able to find the exact numbers, and much of the declarations don't have dates associated with them. So it is also very possible that those officers were sent in June and they have all returned. We have a note within the last week before the president's announcement that there was a surge of officers that came out, and then there was no responsive protest activity. And so they went back to their respective offices. And then even after, I think that they may have plussed up their numbers in anticipation of the president's announcement. But then even then there was some increased protest activity, but it went back down. And
so the answer seems to be you don't know from that we can't know from this record. And I believe counsel on the other side said, well, they haven't all gone home, but I understood him to say, saying indirectly that some or many have gone somewhere else.
certainly a lot of them have gone. And what we also know from one of the declarations is that FPS, they respond to even nonviolent protests. This is their job. They respond to potential threats, and they would use those numbers of officers to go to any kind of that exercise of speech, just in case something becomes violent.
Yeah, you're allowed to protect your officers from an inferable risk of assault. You don't have to wait for them to get beat up. That's crazy.
And so this is squarely within their area of responsibility. And I know we continue to talk about FPS, but we haven't even talked about any of the other federal officers that are at the president's disposal. We have a ton of law enforcement agencies under the president's control. There's referencing in their declarations to circumstances, again, that are outside of what happened in Oregon, or even if there was potentially a bomb threat. Well, we don't have anything that connects the bomb threat to these protesters. And if you do, you have significant law.
There's more than 100 days of violent protests at the ICE facility. Then a bomb shows up, and I'm sure it's an unrelated coincidental event.
Enforcement resources, ATF, FBI, that can respond to those potential threats. That's their job. That's what they do.
The problem that I have with this argument that I'm just trying to struggle with is, the president gets to direct his resources as he deems fit. And it just seems a little counterintuitive to me that the city of Portland can come in and say, no, you need to do it differently. Now, I understand there's a statute here, and we're going to have to review that. But this goes to the level of deference that I think the president is entitled to in these circumstances. And it's not all driven. Would you agree? It's not all driven by what we see on the streets. It's also driven to some degree by what's going on behind the scenes. And you don't have a full view into that.
Yes, the president's taking into account things that are happening nationwide. He has a holistic view of the entire nation for which he's responsible, not just the narrow view of a lawyer from Portland, Oregon. As Joel says here, Antifa is a national threat. If they're amassing and starting trouble in one city, what they're already done in other cities is relevant. I think that's what this judge is leaning to as well. Listen to and look at this lawyer again. It's like she has to reboot her brain. Like you haven't thought this through ahead of time before you showed up for oral argument. She just stops and looks up at the ceiling. Like what is that? I'm going to rewind it just a few seconds so you can see how long these pauses are.
On behind the scenes. And you don't have a full view into that.
I need the Windows reboot sound effect.
I acknowledge that there is certainly information behind the scenes, but We don't have that in this record. And we don't have the defendants coming forward and putting forth anything that shows that the sporadic and minimal instances of violence, criminal activity that was appropriately handled by law enforcement at Portland is part of a greater whole. I think the district court found that, the defendants did not present any evidence that the sporadic violence was part of an organized attempt to overthrow the government. And that's, I think, what they're asking this court to potentially.
But again, she's circling back to her already weak argument. The Whiskey Rebellion didn't involve overthrowing the entire government. Sending the National Guard to Little Rock, Arkansas to force school integration did not involve overthrowing the entire government. This doesn't need to have involved overthrowing the entire government. It only needs to have made it not possible for the president to execute the law with the ordinary forces.
Look at when you're talking about, for example, the shooting in Dallas, that somehow increases the need.
Well, that goes to your rebellion, or that goes to the rebellion designation, but that doesn't necessarily go. I mean, you don't have to have that under prong 3, do you? For the enforcement of the laws.
Well, I'm sorry, I don't understand the.
Well, I mean, enforcement of the laws, you seem to say, well, there's no attempt to overthrow the government. And I mean, that's a fight within the context of whether there's a rebellion under subsection 2. But I don't know why that is relevant to subsection 3, which doesn't have anything to do with rebellion and is just the enforcement of the law.
Look at all the resources our nation is consuming in this affair because we have idiot lawyers like this. I swear to God. They're not making the bar exam hard enough.
Oz.
Well, I agree that the Dallas shooting shouldn't be the basis to send troops into Oregon. And if we're relying on that third prong, then it certainly, it doesn't make that more or less probable.
Can I add just, and maybe my colleagues have final questions too, but I don't want to focus on it, but I'm just perplexed. And I think Judge Beatty may have referenced this. So they reopened the building, they board the windows for protection.
Watch, he's going to get to the zoning violation from the city of Portland.
And I think Judge Beatty may have referenced this. So they reopened the building, they board the windows for protection. And what does the city of Portland do? They issue a zoning violation. Are you defending issuing a zoning violation, telling them to take off the boards that were put up to respond to protesters? Do you think that was maybe ill-advised?
Luckily, in this case,
oh my God, she did a reboot again.
Respond to protesters.
Holy crap!
Do you think that was maybe ill-advised?
Luckily, in this case, it's not something that the court needs to decide to determine whether or not the president's determination was within a colorable basis or within the range of honest judgment. But what we do know is that the circumstances at the time the president authorized the troops, whatever date that might be, they didn't raise to the level that was necessary under the statute. And we would ask that the stay be denied.
Any other questions by my colleagues?
She gave up.
No.
Thank you.
Thank you, Your Honor.
We'll have 3 minutes of rebuttal.
Thank you, Your Honors. I just have 3 quick points that I'd like to make. First, Judge Graber.
All right. I just want to point something out, just from a presentation perspective. So you may know that I've taught from time to time at the FBI Academy at Quantico. And so you get walked around the facility. And they actually have a setup that's like a newsroom. It's a fake newsroom where they put their special agent FBI candidates, the cadets, whatever they call them in the academy, and they train them on how to present themselves in news interviews. So they present well. This guy for the Department of Justice, he's got the winning argument on the merits, but his presentation of himself is terrible. I mean, how small is he prepared to make himself? Why don't they move the camera up close? Why is he so much smaller than everybody else? It's terrible. He sat down during the state of Oregon's argument. It looked like there was nobody representing the Department of Justice. Why did he sit down? Is he tired? I don't understand that. I would want my face to look like my face looks on this live stream. I want it to be the biggest face on the screen. I'm here. And then he's got that crazy high-pitched voice. I mean, is he really only 4 inches tall? Is this like they're using a macro lens to make this little tiny human being appear at something like normal size? I just think it's such a bad look.
We're going to your questions about the basis for the determination. We're not relying solely on the June 7th memo. My basic understanding is the June 7th memo was where the president sort of set out the framework and his understanding and interpretation that violence directed at ICE officers that seeks to impede their execution of the immigration laws is the sort of circumstance that can warrant activating the guard. And the president then subsequently made a determination that those circumstances were satisfied in Portland. If you look at page A52 of our appendix, you'll see that's where the DHS request is. DHS said that the facility in Portland and the ICE office.
Yeah, his audio is terrible. It doesn't even look like there's a microphone on the lectern. It's almost like he's using whatever microphone is built.
Officers and the FPS officers have.
You don't want to make your argument be work for the judges. You want your argument to be easy for the judges. Judges are lazy. If they had a work ethic, they wouldn't be judges.
Come under coordinated assault by violent groups intent on obstructing lawful enforcement actions. These groups have sought to impede through violent protest, intimidation, and sabotage of federal operations. That was the information that was before the president when he made this determination in September. Second point I
feel like the Department of Justice went to the supermarket and they went to the gumball machines. You know, the ones with the plastic, the department and the cap.
The language of the statute talking about a present inability to execute the laws because of the violence that's ongoing and the risk of violence that's ongoing. There is a present impediment to the execution of the laws because the forces are tied down addressing that risk. We've discussed the FPS officers. It's not just the FPS officers. It's also ICE personnel. If you look at page 85.
You have an answer.
You think for Halloween he's going to dress up as Mighty Man?
FPS officers. It's also ICE personnel. If you look at page 85.
You have an answer to Judge Graber's question about how many FPS. There were 115 that were there in July at least, and maybe longer. How many are there? How many were there in September of the additional?
I do not know the answer, and I do not believe the record speaks to that. The citation that the plaintiffs provide in their brief to say that some have gone home is document 4626. You'll have to take a look at it for yourself. My best recollection, I don't have that document at my fingertips. My best recollection is it referenced about 10 people going home. But it's not just the FPS officers. If you look at paragraph 16 of the Cantu Declaration, it says the situation has resulted in FPS having to rely almost exclusively on ICE special response teams for assistance in preventing the violent protesters from attacking immigration officers and the ICE facility. And he explains that their primary mission is to be out in the field, handling high-risk immigration enforcement operations. But they're now having to be diverted to protect the facility, becoming a drain on immigration enforcement as well. If you look at the Walmsley Declaration, paragraph 20, pages A77 to 78, it is to like effect. The final point that I want to make is, although we do think the judge was clearly wrong to circumscribe the inquiry to what was happening in September, I think the district court also did minimize the violence in September. I just want to highlight a couple of documents that are in the record. One is that our supplemental appendix.
So these are acts of violence that the unelected black-robed tyrannical inferior district trial court judge didn't write about in her restraining order against Trump. And that the Oregon lawyer says, well, then we should pretend they didn't happen, that it's not in the judge's record.
A2 to A3,
Counsel, are you now withdrawing what you said earlier, which is that you are not challenging as clearly erroneous any of the specific factual?
There's the trap. I told you it was a trap. I told you it was a trap at the start. When this Clinton judge said, I just want you to make a blanket statement on whether or not you're challenging any particular facts and what they are. This is why she said that. This was the trap she laid.
Findings that the district court did make.
And again, she's conflating between facts and the evidence on the one hand and factual findings made by the trial judge on the other hand. Those are two different things.
As distinct from ignoring certain things?
I'm not challenging factual findings about what she said in terms of X event occurred on Y date. There may have been other events that occurred on other dates that she didn't address. That's not, I think, an issue for clearly erroneous review. But if you look at page SA2 to 3, this is on September 28th.
And that judge, that Clinton judge in the upper left, she asked that question because she knows there were a ton of affidavits submitted in this case, in the record, by ICE, by FPS, about the violence. The judge's restraining order was 30 pages long. It didn't talk about any of the stuff in those affidavits. So she's trying to suggest if it wasn't a factual finding by the judge in her restraining order, it doesn't exist as a fact in the case. That's not how the law works.
This is one of the police reports. It starts out talking first about how a group of these agitators attacked two observers, breaking the driver's window and leaving one of them bleeding heavily from the face. And then it says there were 50 to 60 protesters outside of ICE at the time. Most of them were blocking the facility's driveway in anticipation.
I've read that document. I have a different question about it. Does that not post-date the final document on which you were relying as part of the call-up? And didn't that happen?
He's not relying on a particular document.
September 28th is the memo from the secretary.
Right, and so that's that same day addressing.
Okay, is that the final document on which you rely? And I guess my question is, can you rely on any event that post-dates the mobilization to justify the pre-existing mobilization? In other words, let's say there's nothing that happens at all. This is a hypothetical. Nothing happens, but troops are mobilized, and 2 days later, there are terrible things that happen. Does that go back in time to justify, or does there have to be something at the...
It would go back and justify because the statute allows for the activation and deployment of the National Guard if there's a danger of rebellion. You're allowed, the president's allowed to call out the National Guard if there's an imminent threat of a rebellion. Just like in self-defense, folks, you don't have to let yourself get punched or stabbed or shot before you can defend yourself against the imminent threat of being punched or stabbed or shot. You just have to have a reasonable belief it's about to happen. The president has a reasonable belief that there is a danger of rebellion. He doesn't have to wait for the rebellion to occur first. That's what danger of rebellion means. It could occur.
The time of the mobilization.
I certainly think this evidence is fair game because it shows...
That's not an answer to my question. Can you rely on later evidence to justify a prior authorization?
I think we can rely on later evidence to show that there was a colorable factual basis for the president's determination here because it demonstrates the very kind of risk that can materialize at any time with this sort of violent crowd. But it's not just on the 28th. If you go back a week earlier on September 20th, this was at page A1.
All right, I'm calling it now. The Clinton judge is going to interrupt him again as he's reciting these facts from the record that is harmful to Oregon's case. She's going to interrupt him again, just like she interrupts and talks over her fellow judges, Trump appointees.
104 of our appendix. It says, another police report. FPS agents were busy tonight. There was a group of 50 at the facility. Again, once a marked car drives through, they will flip off, scream, and throw objects at the car, and in most cases run towards the car as if they are going to charge the car. FPS Will Turner called me throughout the night with info about black blockers assaulting people. I received a video from FPS about a report about a journalist who was assaulted by a black blocker with a large sword or stick. To be clear, even if these folks were still at ICE or nearby, we would not be able to address the call or make an arrest with the resources that we have. This is hardly the peaceful and sedate crowd that plaintiffs try to make it out to be. These are violent people. And if at any point we let down our guard, there is a serious risk of ongoing violence. And at some point, the president is entitled, when his subordinates are telling him, we are overstretched, this is unsustainable, the officers aren't available to do their jobs, they're not available to surge to
Oh, he's closing strong. Good for him. I just wish he was more than 3 centimeters tall.
other places where we face violence. The president is entitled to say enough is enough and bring in the National Guard to reinforce the regular forces. We would ask the court to grant a stay pending appeal as swiftly as possible.
Thank you. Thank you to both counsel for your arguments in the case. The case it will be taken under advisement, and we'll respond as quickly as we're able. Case is now submitted.
Okay, so that was this morning. Before I started today's show, I took a look at the docket to see if they had already come to a decision, and they hadn't, but that was 2 hours ago. Let me take a fresh look at the docket and see if they've come up with anything. Let's see. Amicus. Status report. Notice of appearance. No. Nope, no decision yet. I wouldn't expect one this quickly, although it can happen. But there we go. All right, folks. Well, you know what that means. Let's see. I got a super chat here. Troops were deployed because Governor Wallace was blocked.